And if you may, Your Honor.
Wait. So there was an order filed September 19th. The order was for defendant Randall Peterson. He was sanctioned for, he was found in contempt. Sanctioned for a term of incarceration of 30 days and a fine of $1,500 to be paid within 45 days of the order.
And Your Honor, that was paid by Mr. Peterson.
Hold on. The term of incarceration and the fine may be purged on the condition he pay $1,259 for attorney fees incurred. Did he do that?
He did, Your Honor. He did purge to avoid jail. But
Were the March, April, May, and June of 2025 payments made by the defendant?
No, Your Honor.
Mr. Hinton?
Thank you, Your Honor. In February of
Did he make the payments? March, April, May, and June as I ordered in September.
Now, those were dealt with at the time of the sale.
Okay. Were they paid?
Not by Mr. Peterson.
Are they paid?
They are now.
From closing, they were, Your Honor.
Okay. So now we have, that issue's taken care of.
Correct.
Now the issue is these two apparently like coming back here because they can't figure out any way that this should be divided other than the complete opposite way. And so their agreement when they settled this case is the property would be sold, which was like dragging it took forever.
It did.
To get to that point, okay? And you says it's all your fault, okay? And so now their agreement was that it would be sold, placed in escrow, and it would be divided equally after offsets, if any, right?
Technically, what the order that you entered said is be governed by the terms of.
All right. So tell me what they then agreed to do.
So if we could not come to an amicable resolution, and the only resolution that the defendants have proposed.
Well, I don't care. If you can't come to a resolution, then what?
So we have a hearing today.
No, this is a motion to show cause.
Well, it's also in the alternative to enforce the settlement agreement. We can take evidence as to the payments that my client has made and as to the offsets under the holding of Thrasher versus Watts, Your Honor.
Okay. So it's not a motion to show cause because there's no violation of the order at this point.
Well, your order also said you would reserve on any further findings. And our argument is he was ordered to pay it and while he was living there and to pay it out of escrow instead of paying it directly. That should have been that should not be an offset.
This isn't the issue is I don't know how long has this case been going on?
Since 23, Your Honor.
When was it filed?
I believe December of 23, but I don't know the date offhand, Your Honor.
November 27th of 23.
Okay. All right. So there is no motion to show cause. So that's dismissed.
Okay.
Okay. So now you have a book of exhibits. Did you look at these exhibits?
Yes, Your Honor.
And in fact, Your Honor, to interrupt, the appraisal and the closing statement have been stipulated to ahead of time, Your Honor.
That's somewhere in these
Yes,
exhibits?
that'd be Exhibit E and Exhibit F. The appraisal is when Mr. Peterson came on title, and then the closing statement, Exhibit F, is what the value was at the time of the sale in June of last year.
So you believe, how much is sitting in escrow?
About $195,000, Your Honor.
And you believe your client is entitled to what?
Honestly, Your Honor, all of it.
Honestly,
All of it, because when she,
195,000?
yes, Your Honor. And the rationale for
And
that.
you believe your client is entitled to what?
50%. It's close to 98,000.
And Your Honor, if I may,
Nope, not yet. Okay, so the agreement, settlement agreement says that the parties shall mutually divide the net proceeds of the sale, taking their respective contributions to the property into consideration, including but not limited to contributions for the down payment, mortgage payments, insurance, maintenance, and improvements, right?
correct, Your Honor.
Okay. So if he's not entitled to any money, if that's your position, why was that even included in the settlement agreement?
Because, Your Honor, when Thrasher versus Watts, which we.
Why was that included in the I don't give a shit about Thrasher.
Because we wanted to prove what we've put into it, and it's imperative to
Okay,
understand.
so did you know at the time of the settlement agreement that your position was he was entitled to nothing?
No, we wanted him to prove what he thought he was entitled to, Your Honor, and he hasn't done that. We bought the house in.
Did you
2000
provide documents on what you believe he's entitled to?
Yes.
Okay, so to your satisfaction, he hasn't proven that.
Your Honor, if I may, the documents they provided were a 2-page handwritten.
Okay, I don't care what they were, okay? Their obligation was to provide some proof that he's entitled to something. Your obligation was to provide some proof that she's entitled to something.
Correct,
If you can't agree, then here I am,
correct.
okay? So I don't care if you think that his list was horse shit, or he cares if he thinks yours was horse shit, doesn't matter to me, okay? You want to argue to me without any type of evidence that it was a horse shit document he gave you.
Your Honor, we bought the house in 2011.
I don't
No, this is
care.
very important,
It's
Your
not
Honor.
important to me, okay? What's important to me, okay, is that you claim that you may be entitled to every penny from this thing, okay? He may be entitled to half of it, okay? So call your witnesses and let's get on with it.
Thank you, Your Honor. As a first-
Now, we've got 7 other hearings this morning too.
It will be quicker than you think, Your
All
Honor.
right, go ahead.
Thank you. As first witness, I would call Andrea Mackey.
Raise your right hand, please. You swear testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, go ahead.
All right, go on.
You can stay there.
Okay, then use that exhibit.
Okay.
All right, please state and spell your name for the record, Ms. Mackey.
Andrea Mackey, Andrea Mackey.
And at all times relevant, you were the owner of the property located 11812 Painesville Warren Road, Concord Township, Ohio, 44077, correct?
Yes,
I'm sorry?
yes,
Speak up so the judge can hear you and the court reporter can take it. And did you purchase that property on or about February 28th of 2012?
yes,
And was the purchase agreement for that entered into by you? Did you have a purchase agreement?
Yes.
Turn to Exhibit A, please. Is that the purchase agreement?
yes.
And who is Andrew Janis?
My father,
So you and your father purchased the home on that date, correct?
yes,
And was the purchase price $150,000?
Yes.
And did you personally make the earnest money deposit?
Yes.
And that was for $1,000?
Yes.
Was that mortgage taken out?
Yes.
And did you make all the payments on that mortgage from that time? And we'll go into the next date, but did you make all the payments on that mortgage?
Yes.
And at that time, Mr. Peterson was not living with you or involved in any way with you, marriage-wise, correct?
Correct.
And to this, you were never married to Mr. Peterson, correct?
Correct.
At no time during any of this were you ever married, correct?
Correct.
And so he made no payments at that time in 2012, correct?
Correct.
And you have proof of those payments being made?
Correct.
And those were attached to my October 31st motion as Exhibit E. And I also, if you turn to Exhibit B, are these documents that you provided?
Yes.
And we provided those to the defendant and his counsel, correct?
Yes.
What period of time does Exhibit B encompass?
From the time that Mr. Peterson, basically from the time that Mr. Peterson was involved in 2019 and prior payments on certain aspects, but the majority of the documents are from the time that Mr. Peterson and Ms. Mackey lived in the house
All
at,
right, I see one from, the first one, 7/1/25.
correct.
Do you have statements from Third Federal? From
Yes, I do, Your Honor.
Going back, how far from 7/1/25?
I believe from the beginning, she's provided every statement
So
ever
from
made
12?
on the house. Correct,
From 2012, from what, April?
correct, all the way to 2025 when the house sold.
All right, go ahead.
In short, these documents prove the payments you made on this property, correct? Property in around February of 2012 officially, correct?
Correct.
If you turn to Exhibit C,
Yes.
and Your Honor, that would obviously be self-authenticating through being a recorded document with the Recorder's Office. Mr. Peterson was not on that deed, correct?
Correct.
Now, did there come a time that Mr. Peterson was placed on the title of the property?
Yes.
And if you turn to Exhibit D, is that the document that shows Mr. Peterson becoming an owner of the property?
Yes.
And that was on or about 12/5/19, correct?
Correct.
And that document, Your Honor, we would argue speaks for itself as to the interests of the parties. So at that time, Mr. Peterson was added to the title, correct?
Yes.
And at that time, were you married to Mr. Peterson?
No.
At any time from
For the court draw near, the Honorable Judge J. Cedric Simpson presiding.
And good morning, everyone. Court does call the case of Great Arbor Properties versus is it Akin Fenwa?
Akeem Fenway, Your Honor.
Akin Fenwa. All right.
Yes, Your Honor.
For the record, Your Honor,
Okay.
Stuart Collis on behalf of Great Arbor Properties.
All right. This non-payment of rent case, what's your claim?
Your Honor, I've talked to Ms. Akeem Fenway. If we could adjourn this matter a week, that'd be great.
All right. Ma'am, is that what you'd like to do?
Yes, Your Honor.
All right. Let's see, 23rd. We'll adjourn it to January 23rd, 2026 at 1 p.m. That's an in-person proceeding, folks. All right.
Thank you very much, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you, Mr. Collis. Take care.
Clark Road Family Dividend Housing versus Brianna Holcomb.
Good morning, P72714 on behalf of Clark Road family.
Thank you. And do you have Holcomb?
Hi, yes, good morning, Your Honor.
All right, there you are. Okay, it's because we're on Zoom, I have to have you talk so it lights my screen up, so. All right. All right, what is plaintiff's claim in this case?
Good morning, Your Honor. This is for a non-payment of rent. I don't believe we've received a payment since April. So that's our claim today.
All right, how much is plaintiff's claim?
So there's $2,349.55 in past owing rent $239.40 in costs and fees for a total of $2,588 and 95 cents.
Thank you. All right, Ms. Holcomb, how are you intending on getting that paid?
Hi, Your Honor. I'm sorry, I've been sick and my car has been down, so that has been the reason for the delay in payment. I recently applied for cash assistance to help me with my monthly payment until I find another job, which the program will help me find a job. And then I also applied for Hawk last week to help me with the past due balance.
Okay, do you have an appointment with Hawk?
Yes, it's scheduled for January 26th at 11 a.m.
Okay, at 11 a.m. And the cash assistance that you're talking about, who's that through?
The Department of Human Services. It's a monthly subsidy.
Department of Family Services. Okay, so here's what I'm gonna need you to do. You're entitled to a 1-week adjournment. I will adjourn this matter to January 23rd, 2026 at 1 p.m. What you'll need to do is in your packet, there's a rental assistance form. You should have a tracking number for the Department of Family Services, or at least an account number or some other reference number. You need to fill that out. That needs to be filed with the court to buy you additional time. It needs to be filed with the court by Wednesday.
Okay, so the DHS application is for cash assistance. I applied to Hawk to help with the past due balance.
Oh, I understand what you're telling me.
Okay.
But if
okay.
you're applying for assistance to pay rent, you need to fill that out and put it on the form so that I can take a look at it. And you need to do that by next Wednesday.
Okay, by next Wednesday. Okay.
All right. All right.
Okay,
So I'll
so-
adjourn it out to the 23rd at 1 p.m. That's an in-person hearing.
Thank you.
If I may, could you
Thank-
please provide that to plaintiff as well?
Yes,
Thank you.
no problem.
Maple Heights Apartments versus Roberta Nesmith.
Morning, Your Honor. Alex Olson on behalf of plaintiff.
Can you hear me?
Ms. Nesmith, there you are.
Yeah.
Okay. I've got both parties. Okay, what is plaintiff's claim?
This is a non-payment of rent matter. I show rent to retain of $1,645, court costs of $170.09, for a total outstanding balance of $1,815.09.
All right. And Ms. Nesmith, how are you intending on getting that paid?
My father is willing to help me. And just for the record, the lady that was here when I was moving in, matter of fact, it took me 6 months to move in here because she was saying she has no idea what she's doing. But she told me that we have till the 5th as a grace period. So sometimes I know I've had to use that. And I'm pretty sure that's why I'm behind in late fees, I think.
Okay, I'm not sure I understand that, but you say your father's gonna help you out?
Yes.
All right. So how much do you think in the next week you can get paid on this?
Probably all of it.
All of it?
Yes.
Okay. Here's what I'll do. I'll indicate in my file that you're gonna pay the balance. You're gonna do that. You think you can do that by the 22nd?
Oh, of course.
Okay. So try to get that paid by the 22nd. I'll adjourn the hearing out to the 23rd, 2026 at 1 p.m. If all of that's paid, and just check with the landlord and make sure that everything's paid, then I don't need to see you on the 23rd.
Okay, what was the balance again?
I had
show-
181509. Is that right?
Correct, yes.
181509. Okay, okay.
Okay.
All right, thank you so much. Am I done?
S&C Holdings versus Lorianne Pearson.
Ready, Your Honor.
And I think Miss Pearson is here.
Yes.
All right, go ahead, counsel.
Good morning, Your Honor. Tracy Thomas appearing on behalf of the plaintiff. This is a non-payment of rent case. Rent to retain possession is $2,408. Court costs of $157.80 for a total of $2,565.80.
2,500, I'm sorry, give me that again. Total.
$2,565.80, Your Honor.
Thank you, sir. All right, Ms. Pearson, how are you intending on getting this paid?
I applied at Sear and they denied me, but I have an appointment with Hawk. I did the intake. My appointment with Hawk is on the 29th at 9 a.m.
29th at 8 a.m. All right. You're at least under the 3,000 limit. I cannot adjourn it out to that date. You said the SER denied you?
Yes.
All right. So what I'm going to adjourn this to the 23rd, 2026 at 1 p.m. What I'm going to need you to do, ma'am, is I'm going to need you to either contact Mr. Thomas or contact your landlord, see if you can work something out regarding the payment of this, all right? In the interim.
Okay. And my Hawk appointment is on the 29th.
I heard you. Okay, but I have authority to give one adjournment of an adjournment of a week.
Okay.
So what I'm going to suggest you do is talk it through with counsel or talk it through with your landlord and see if there's additional time or the like, and see what you guys can work out. All right?
Okay.
All
Okay.
right.
Thank you.
We'll see you at 23rd, 1 o'clock. That's an in-person hearing. Thank you.
That's in person at the court.
Yes, ma'am.
All right. Thank you.
Thank
Thank you, Your Honor. Have a good day.
Thank you, Mr. You do the same, sir. Six Trails versus Sean Ames.
Good morning, Judge Joe Joseph, the plaintiff.
All right. You don't. Sean Ames, they are not here. You paid for the second service. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Judge.
Go ahead, sir.
Thank you, Judge. At this time, based on the defendant's failure to appear today, we do move the court for entry of a default judgment for possession only. We are showing rent to retain at $1,797. Court costs at $177, totaling $1,974. We are requesting a judgment of possession of that amount with a writ date of January 26.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days. Six Trails versus Jordan Oren.
Again, Judge Joe Joseph for the plaintiff.
And I think he's here.
I'm here, Your Honor. Good morning.
Good morning. All right. What's the plaintiff's claim in this case?
Judge, we are showing a balance through today's date of $3,113. Court costs are $177, and that totals $3,290.
All right. And sir, how are you intending on getting this paid?
Your Honor, I get paid next week, and I'm gonna need to ask for some help from a family member probably. I'm not sure I can get the whole balance paid next week, but I should be able to pay some of it.
Okay, how much do you think you can get paid next week?
At least 1,000 of it.
Okay, at least 1,000. Can you get that paid by the 22nd?
I should be able to, Your Honor.
Okay, so I'll put that in the file. I'll adjourn this out to the 23rd, 2026, 1 p.m. That's an in-person hearing. I'm going to suggest in the interim, you contact your landlord or contact plaintiff's counsel and see if you can work something out by way of a conditional dismissal to get this paid down, okay?
Okay, thank you, Your Honor.
All right, thank you.
Thank you, Judge. Have a good weekend.
All right, you do the same. Court calls the case of Harbor Cove versus Joan Davies.
Good morning, Your Honor. Brian Butchart, P66250 for the plaintiff.
And Davies is here. Oh, there she is. All right, Ms. Davies, you'll have to unmute.
Okay, there we go.
There you go. All right, very good.
Thank you.
All right. And what is plaintiff's claim in this case?
Judge, we're showing current past due rent of $3,143.80. We We have court costs of $170 for a total of $3,313.80.
Ma'am, how are you intending on getting this paid?
Okay, Your Honor, I have contacted Hawk, so I'm working with them. I've also applied to DHHS for for help through them. And I'm also in contact with the Housing Bureau for seniors. So the summons I have shows total rent due $1,571.90, not 3,000.
Okay, and ma'am, that's going to be through December. We're in January now.
Yes, the total amount due is $1,571.90. I don't owe for 3 months.
Well, ma'am,
Sir, yes, Honor.
when you say $1,570.90,
Uh-huh.
that's what's on the complaint, and that's what you're looking at. If you look down at the bottom of the complaint, you'll see a date of the signature that's what you owed as of December 20th.
Okay.
And now we're in January, so they're entitled to get their January rent.
Okay, I understand.
Okay, so
Yeah.
that's how you're getting there.
Okay.
All right. So ma'am,
yes, sir.
I'll tell you, if Housing Bureau for Seniors gives you a reference number, you'll need to include that on the form that's contained in your packet called the rental assistance form.
Okay.
Okay? You did get a track, if you applied for state emergency relief, you did get a tracking number.
Right.
And that you'll also need to put on that form, and you'll need to file that form with the court within or by next Wednesday.
Okay, where do I get the forms, Your Honor? I guess I'm not understanding.
In your packet, in the packet that was served on you.
Yes, sir.
There's a document that at the top should be called the rental assistance form.
Okay.
You see that?
Yes, I'm getting there. 1 second. Fingers are not turning the pages. Request an order. Oh. Well, if it's in here, I'll find it, Your Honor.
Okay, it's in there.
Oh,
or
I see
if
it.
necessary, ma'am, or if necessary, you can come down to the court and get a copy of the form. Fill that out. It needs to be filed with the court by next Wednesday.
Okay.
Okay.
I can do that.
How many people are in your unit?
Just myself, Your Honor.
All right. So just so you know, and just to give yourself some reference, if you get a state emergency relief, that will only, if they award you the maximum amount, that's only going to be about $410.
Okay.
Okay. So just so
I'm sorry,
you're
go
not
ahead.
looking at that. All right. But you don't have an appointment yet with Hawk, correct?
Correct, but I have the name of my, the caseworker that's working with me. I also have another one with, the Bureau for, Assistance with.
For seniors.
Yes, thank you.
All right.
So when I spoke with the last agent with seniors, she said, well, usually they'll give you about 2 weeks to put the money together. And I think that's what she was saying, that it would take that long for them to get the assistance to me.
All right. We'll figure all that out, but Hawk will also kind of lead you in that direction. So ma'am, I'm going to do this. I'm going to adjourn this out 1 week to the 23rd, 2026 at 1 p.m. That's an in-person hearing down at the courthouse.
Okay.
Okay. And then we can see exactly where you are.
Oh,
all right.
That sounds great. Thank you, Your Honor.
All right.
Thank you, Your Honor.
Have a good day.
Thank you, sir. Harbor Cove versus Stephen Saxon.
Brian Butchart again on behalf of the plaintiff. Good morning.
Okay.
And I think Mr. Saxon is here.
Good morning.
Good morning, sir. All right. How much is owing on this case?
Your Honor, in this case, we're showing a balance of $2,989.80. We have court costs of $170 for a total of $3,159.80.
All right. All right, Mr. Saxon, how are you intending on getting this paid?
Well, I just started my job last month, so I'm just trying to catch up here. I plan on making a payment of $14.95 on February 6th. And I plan on making the next one on my next paycheck, which is 2 weeks from that date. So I believe it's February 20th.
Okay, I see what you're doing. And so here's what I'm going to suggest. You're going to need to contact the attorney for the plaintiff, see if you guys can work out a conditional order of dismissal or something along those lines regarding that payment, because your payments that you have, I get why you're doing it, clicks you into the next month, and that's going to be a problem because you're going to accumulate rent at that point. Okay?
Yes, sir. I'm also working with the Housing Bureau for Seniors too, so.
Okay.
Not a little
Thank
bit.
you for letting me know that. So they may be able to help you catch up, and then you can start with February.
Yeah, that's
All right. If they give you a reference number, you'll need to fill out the rental assistance form, submit it to the court by next Wednesday. Okay?
What's that called again, Judge?
The rental assistance form, it's in your packet,
Okay.
or you can come down to the court and get it, or there's a QR code if you know how to use it on your screen. That'll take you right to that form.
I appreciate it.
Okay? All right. So I'll adjourn this to the 23rd, 2026, 1 PM. That's an in-person hearing. So we'll need to see you down at the courthouse if it's not paid. Understood?
Is that in January, sir?
January 23rd. Yes, sir. Next week.
Thank you very much, sir. I appreciate it.
All right. Thank you.
Thank you.
Haverhill on Clark versus Khadija, is it Kissy? Or Cece?
Brian Butchart again on behalf of plaintiff. Good morning.
Good morning.
Good morning. And how do I pronounce your name now that I've mangled it?
Khadija, Cisse.
Cisse. Okay. Thank you. All right. And how much is owing on this account?
Judge, we're showing a balance of $3,049, court costs of $170, for a total of $3,219.
And ma'am, how are you intending on getting that paid?
Okay, I would like to start by saying that I've been in touch with the property manager at the apartment complex. And since I lost my job, I've been struggling, and I've talked to her about it in open communication. I did just pay January's rent, so I only owe 2 months. $2,999 is what I received on the court documents. It's not 3,000 because January's rent was already covered.
Okay, hold on. When did you pay that?
January's rent, I paid it on the 6th of January. I went to the office, I dropped my money orders there.
Okay, all right, ma'am. Slow down. Counsel, you don't have that on your ledger, I take it.
Judge, my client has actually 3 credits on the ledger dated January 8th, 2 in the amount of $500 each for $1,000 and another of $487. So a total of $1,487.
Okay. So that's probably that rent that you paid. Okay, that's been
Correct.
taken into account, ma'am. So they're coming up with this number. So you may want to talk to the landlord and figure out where this number is coming from, because they've already taken that off on your account.
Yeah,
Okay,
because
I
some
will say-
court document that I received, it doesn't even show a balance of 3,000. It shows 2,999.
Judge, I will
And
say,
ma'am, like I said to the other individual, if you look at the bottom, that was signed in December. So that's what you owed in December. Okay? And
Okay.
then what you're gonna have is you're gonna have the $299.99, and then you're gonna have court costs, which is gonna bring you up around that $3,200 figure.
Okay, I've been in touch with Hawk. I spoke to the caseworker. I already have an assigned caseworker. We've been emailing back and forth. Even yesterday, she's aware my court date was today. She's already had taken on my case already. She had me sign a release of information yesterday in order for her to be in touch with the landlord. So that's where we're at with that
Right.
process right now.
Okay, that's understood. And so that you know, your balance would have to be 3,000 or under for
Correct.
Hawk to assist you.
I'm aware.
So, okay, between now and next week, is there anything that you're gonna be able to pay me?
Between now and next week, I mean, I'm still unemployed, so I'm just
Well,
waiting
then
on the worker
Then
to
the
see
answer
what's
might
gonna
be
happen.
no. So there's nothing you can pay between now and next week.
No, I'm waiting on the worker
All
to
right.
see what's gonna happen.
So I'll adjourn this to January 23rd, 2026. at 1 PM. That's an in-person hearing at the courthouse. Keep in touch with your landlord, let them know what's going on with Hawk, and we'll see where we are next week.
Okay,
Right.
you said it's in person at 1 PM?
It is in person at 1 PM.
If the balance is not paid by that date?
If the balance is not paid in full, yes, you need to be down at the courthouse.
Then if it is, I don't need to attend, right?
Pardon?
If the balance is covered, then I wouldn't need to attend court, right?
If everything is paid, I don't need to see you.
Okay, no problem. Thank you.
All right, thank you.
Yep.
Haverhill on Clark versus Sherelle Gamble.
Brian Butchart again on behalf of the plaintiff. Good morning.
And you don't have them.
Sorry, I was trying to unmute my mic.
Where? Oh, there she is up there. Okay, I'll need a camera, ma'am.
I have a broken camera right now. I do apologize.
All right. All right, counsel, what's owing?
Judge, we're showing a balance of $9,911, court costs of $170 for a total of $10,081.
All right, ma'am, how do you intend on getting this paid?
I talked to I think the property manager's name is Latasha. I did speak to her. She informed me that I was able to do a 3-month payment plan with Haverhill. I had within 7 days to fill out a sheet and then give it back to her. That was around like Christmas, New Year. So I did give it back. She told me I had to wait for court today to see what was going on with that. But I did give them a payment plan that I was able to afford and work with. That's what she informed me of. So I said that I can do $3,000 a month. I felt like that was I thought that was good enough, $3,000 a month, and then $300 every Friday. So that would come out to like over $12,000. But again, I haven't heard anything.
Okay.
I don't know if
So
my
here's
payment plan was okay.
All right, counsel, are you aware of that or no?
Judge, I do see a payment plan request signed by Ms. Gamble. So I do see that she's made the offer of certain payments. I guess I would have to check with my client to see.
For the court is Ms. Collier, right?
Yes.
Represented by Mr. Madden. We have Mr. View from the prosecutor's office, Officer Torek from probation. We are here today for a final violation hearing in the 24 case, pretrial in the 25 case. It's my understanding Ms. Collier is going to enter a plea of guilty to the F3 trafficking, and we're going forward with sentence today. Is that accurately stated?
Yes, Sean.
So, Ms. Collier, I know it hasn't been that long since we went through all of this, but I want to make sure that we have a clean record in this case. How old are you?
41.
How far did you go in school?
I graduated.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Just the medication from the.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Could you scoot your chair up a little bit so you're closer to the microphone?
Yeah.
That's okay. Are you a United States citizen?
Yes.
We've had some discussions about your case today. If you enter a plea of guilty to this charge, on the new charge, I'm going to sentence you to 36 months in prison. I'm also going to revoke your probation in your other case and sentence you to 9 months in prison. There is a joint and recommended sentence, which I intend to accept, is that I will favorably consider you for judicial release after you've been in prison for a period of 18 months. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Madden before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of trafficking in a fentanyl-related compounds, 3rd-degree felony, punishable by up to 36 months in prison and a $10,000 fine. Also carries with it a mandatory fine in the amount of $5,000. And there's a period of post-release control that is optional for up to 2 years. Your rights really haven't changed that much since we went over them a couple of years ago. You still have the right to make the state of Ohio prove that you're guilty, either unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you, to compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on or about August the 13th of 2025 in Warren County, state of Ohio, that the defendant did aid and abet another in trafficking of a fentanyl-related compound in an amount that exceeded the bulk amount.
Anything on those facts, Mr. Madden?
No, Your Honor.
Ms. Collier, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to go into the matter of the sentence today?
No, Your Honor.
I also find in the 24 case that Ms. Collier has violated the terms of her community control. And we have, what's her jail days?
Your Honor, on the 24 CR case, she has a total of 50 days credit.
Do we have an indigency affidavit? I'm sorry, one more time.
50 days.
50 days. Mr. Madden, anything on behalf of Ms. Collier?
I'd just like to point out, speaking with the probation officer, I indicated that she was doing very, very well prior to this. And I believe, as I see with so many of my clients, that it's really who she got involved with that created the situation. And then she takes responsibility for that. But had she not been with those two gentlemen, don't think she'd be sitting there in front of you today, Judge. So I don't think she'll be back. And she says, I'm not coming back, right?
Correct.
Anything you want to tell me, Ms. Collier?
Not at the time.
All right, court is going to sentence you to 36 months in prison on the 25 case. I do find that you're indigent for the purposes of paying fines and costs. You have an affidavit there for you to fill out. So there's not going to be a financial sanction. And I'm going to give you, let's see, the credit would be in the other case,
I think
right?
it's 0. She was arrested. She was actually taken into custody on the PV prior to.
Right, so we have
she's
0 days of jail time credit. This includes an optional period of post-release control. That means the adult parole authority can, but it's not required to supervise you for up to 2 years after release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically, whichever of those is the longer period. It's automatically consecutive to the sentence that you would receive for the new felony. I'm going to order that this sentence be served consecutively to the 24 case, because I think a consecutive sentence is necessary to properly punish you, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. So you'll serve the 9 months in the 24 case first, and then you will start the 36 months in this case. In the 24 case, I find you have violated the terms of your supervision, and I'm going to impose 9 months in prison. That also carries with it an optional period of post-release control of up to 2 years. And we have the 50 days of jail time credit in that case. Anything else we need to do? Anything I forgot?
No, Your Honor.
Appellate rights?
Yep, that's always at the end.
No, nothing else.
All right. Finally, Ms. Collier, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Good luck to you, Ms. Collier. The judicial release, that's not self-actuating. You have to send me a letter that lets me know that that's what we're going to do. Okay?
Thank you.
All right. That's all.
Did you mark the box at the bottom? I left them open because I wasn't sure.
I did.
Thank you.
Right?
If my client is okay with that, and then we can formalize that into an agreement.
All right, very good. So what I'm going to do, Ms. Gambles, I'm going to adjourn your case out to January 23rd, 2026, 1 p.m. If there's going to be a payment plan, that could be done by way of a conditional dismissal, and the paperwork would need to be filled out and everything would need to be memorialized for entry with the court.
Would I need to
Okay.
fill out anything else on my part between the court or the attorney?
Your Honor, if
I
may.
don't need anything else from you. But the payment agreement, if the landlord accepts the request for a payment plan, then you'll need to, that somehow has to be memorialized in writing.
Okay.
So Ms. Gamble,
Okay.
I'll try and communicate with you. I'm sure the property manager has a good phone number for you, so I'll do my best to communicate with you probably either later today or sometime on Monday, okay?
I did. Yes, I did try to contact you. The number was a totally complete different number on the voicemail. So I do apologize. I did not want to leave a voicemail to a random number.
No problem. We'll reach out. We'll get it done.
Okay. Thank you very much. You guys have a good day.
You do the same.
Thanks.
Court does call the case of Haverhill on Clark versus Talib Mahan.
Yes. Hello.
Hello.
So, the case is for my dad and my mom. My mom doesn't speak a lot of English, so I'm translating for her.
Okay, and who are you?
I'm their daughter.
Does the daughter have a name?
Yeah, I go by Gusik.
Like, say it again?
By Gusik. You can just call me G. That's my first initial.
Just call you G?
Yeah.
That's my son's first initial. I don't know. I'm gonna have a problem calling you G. That's what I call him. But we'll
It's
work
okay.
on that. All
Thank
right. So, all right, counsel, what is the claim in this case?
Judge, according to my client's records, there is currently $1,850.32 in rent, $170 in court costs for a total of $2,020.32.
And ma'am, and we've marked our file. Your mother would need an Arabic interpreter, is that correct?
Yeah, but I have class at 10, so I was just asking, I think somebody that's in the court if I could just be next so I can finish it for them and go to my class.
Okay, we'll get you out of here.
Thank you.
What class is it?
It's psychology.
You don't need that. No, I'm kidding. All right.
I'm trying to be a lawyer. That's why I need it.
What?
I am.
We got enough of those. Why do you want to do that? Okay, never mind.
I want to work with you.
Uh-oh. All right. So how are your parents intending on getting this paid?
So we did speak with the office, like the leasing office, and they did agree on a payment plan for us because we mentioned to them that my dad was in the hospital. He had a stroke and he was there for 2 months.
Okay, I'm sorry.
Yeah, for the last 2 months. So that's why it kind of like passed by and we didn't really think about it that much. But we did speak with the leasing office.
Okay. Here's what I'll do. Counsel, do you see a note for our request for a payment plan?
Judge, on this one, I do not have that note. Certainly not disputing what she's telling, Your Honor, but I just don't have any information on it.
So here's what I'm gonna do. I'm gonna adjourn your case out to the 23rd at 1 p.m. That's an in-person hearing, okay? And we can see where we're at with the payment plan. Just make sure with the landlord that the request has been sent in and maybe something can be set up at that point, okay?
Okay, so we should just let the office know to send you guys a letter stating that there is a payment.
Yes,
I think the way I understand the procedure is you have to make the request for it and then the office makes a determination about the payment plan. And then that, if they say yes, then I think council's gonna be working hard to try to get that memorialized, and then it's got to be entered into the court.
Okay, and then, but we still do have a hearing, you said when?
Yes, it'll be next Friday at 1 o'clock. That's an
Okay.
in-person hearing.
Okay, is it gonna be at the Washtenaw?
Yes, at my courthouse down on, by the sheriff's department.
Okay, perfect.
Okay?
All right, thank
All
you
right.
so much. I appreciate you.
You're welcome. And are you gonna come with your parents? So
I
everybody
probably
can see?
will.
All right, so everybody can see this future lawyer?
Thank you.
All right.
Thank you
Take
so
care.
much.
We'll see you
too.
guys in a week.
Have a good one.
You too. Haverhill on Clark versus Cameron Griggs.
Ryan Butchard again on behalf of the plaintiff. Good morning.
We have them. Cameron Griggs, we do not have them. I don't see second service paid for. Well, it
Hello?
says second call.
Hello, Cameron?
Hello, what's your name?
Yes, Cameron Griggs.
Okay, so you're here. Okay, I will need a camera, sir, if it's available to you. What is plaintiff's claim in this case?
Judge, in this case, we are showing a balance of $11,871, court costs of $170, for a total of $12,041.
All right. Mr. Griggs, how are you intending on getting that paid?
I had spoken with the property manager, Miss Latasha. I had turned in a payment plan to her. I don't know if she ever agreed to it or not. She never responded back. I emailed her about it, but she never responded back.
Okay, hold on a moment. Counsel, do you see that or?
Judge, I do see one on Mr. Griggs' file. I will communicate with management to see if they're okay with that.
Okay.
And then I can reach out. Mr. Griggs, I assume the manager has a good working phone number for you, sir?
Yes, sir.
Okay. All right. So we'll
All
reach
right, fantastic. So Mr. Griggs, here's what I'm going to do. I'm going to adjourn your case out to the 23rd, next Friday, 2026. That's at 1 p.m. That's an in-person hearing. So you'll need to come down to the courthouse. If they work through the payment plan and everything, then they'll have presumably paperwork that will be entered with the court regarding that, okay?
Yes, sir.
All right, thank you.
All right, appreciate it.
Your Honor, if I may, real briefly,
Yes.
I do see a young lady that's on today. She was a defendant in one of the cases that we filed, but we have dismissed it. Is it okay if I just announce her and let her know she's?
Yeah, what's her?
I see, I'm going to mispronounce it, but Arely DeLeon?
Oh.
Yes, that's
there she
me.
Judge, we were informed that she's vacated, so I think we've submitted a dismissal on that case.
Yes. Ms. De Leon, there's a dismissal in your case, so that case has been dismissed or will be.
Okay, thank you so much for letting me know.
All right, you take care.
Thank you, Judge.
Bye.
Thank you. Haverhill on Clark versus Kayla Ritchie.
Brian Butchart on behalf of the plaintiff.
Good morning, Your Honor.
And good morning. Okay, what is plaintiff's claim in this case?
Judge, in this case, we are showing a balance of $4,794, court cost of $170 for a total of $4,964.
All right, and ma'am, how are you intending on getting that paid?
So I did lose my main source of income in December, and I have not been able to communicate with the property manager as of lately, but I did submit a payment arrangement. I have most of that payment for today. It was due today. I made the first payment in December, and I do start a new job on the 2nd of February. I did contact, sorry, I have my notes right here.
No, it's okay. Let me just try to understand what you're telling me. You've been in contact with the landlord. You submitted a repayment request.
I did. I've submitted a payment arrangement in the office on December 23rd of 2025 for monthly payments of $1365 until April.
All right. So let me just ask you this. You said that you have most of something. What do you have most of?
Most of the monthly payment for today.
Okay, so how much can you pay between now and next week? Why don't we start there?
Right now, I have a total of $1,062.
$1,062?
Yes.
Okay, so here's what I'm going to tell you to do. Get that paid over to the landlord.
Yeah.
Okay. And then I'll adjourn your hearing out to the 23rd, 2026 at 1 p.m. That's an in-person hearing. Okay. And counsel, you see a request for the payment?
I actually do not see one in this file, Judge, but I'll certainly
Okay.
my client and speak to them about
All right. So they're going to talk to the client. They're going to then be in contact with you see if you guys can reach an agreement. We can get it memorialized in court and then it entered and then everything will be all set. Okay, ma'am?
Okay, that's fine. But I did, I gave it to Latasha directly and she signed it right then. and there.
Okay. Oh, I don't think anybody's disputing that you may have done it. It's just not with the file that council has.
Okay. That's fine.
Okay, so that part will all work out. We'll just try to get everything all set here and try to get the payment plan, but make sure to get that payment into the landlord, okay? And then we'll see you next week at 1.
Okay.
Okay, thank you.
Thank you, Your Honor.
Haverhill on Clark versus Myra South.
Brian Butchart again on behalf of the plaintiff. Good morning.
Hi, good morning.
Where is she? Oh, there she is. Okay, Miss South. All right, how much is owing on this?
Judge, my client's records indicate a balance of $7,554.78. We have court costs of $170 for a total of $7,724.78. Judge, in anticipation of a potential question here, I do not have a proposed payment arrangement in my file.
Okay, yeah, all right. Very good. Yeah, I'm seeing a pattern here. All right, Miss South.
I wasn't even going to say it either.
How are you intending on getting this paid?
All right, so, oh my goodness. I just recently made a payment. I want to say the beginning of this week in the amount of $700. So back in November, I lost my job. I lost my vehicle, so I wasn't able to make my payments as I should. But I was able to start work December 8th. So, long story short, I plan on paying with my employment. So I get paid every 2 weeks. I plan on making at least a payment of $700 or $800 per 2 weeks. Also, I've been in contact with Hawk, and being that my balance is higher than the $3,000, I am looking.
Officer Rose from probation. We're here today for a final violation hearing. Mr. Gibbs, does your client wish to have a contested hearing in this matter?
No, Your Honor, we would like to waive the hearing due to the violation.
Mr. Reed, do you understand the rights you're giving up by admitting to the violation?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
Do you admit or do you deny that you violated the terms of your probation?
Yes, Your Honor.
Based upon your admission, I find you have violated the terms of your supervision. We have 137 days of jail time credit, right?
Yes.
Mr. Harris, anything from the state?
Your Honor, my understanding is he is accepted to CCC. I know that at the last pretrial, we were discussing treatment options, and that appears to be viable.
Officer Rose, what's the plan?
The plan, Your Honor, is to have Mr. Reed complete the CCC program. It's a higher level of care. They will also accept with all of the health issues and background charges. He is eligible, and they will help him with aftercare as well.
We screen him for the coach and they don't want him, right?
Correct.
All right, Mr. Gibbs?
We're certainly on board with CCC, Your Honor, and thankful for this court's.
Anything you want to tell me, Mr. Reed?
No, Your Honor. I'm very thankful for the opportunity to have another shot at getting my life right and just turn this whole thing around. And I believe that I can complete probation. I was once on parole. I finished that. And I got off that successfully. I think that I can do well at CCC, sir.
All right, court is going to continue you on probation. I'm going to modify the terms of your supervision to order that you enter into and successfully complete the CCC program, plus be on a term of 45 days of electronically monitored supervision with a curfew upon your release. I'm going to give you credit for the 137 days you've already done. Good luck to you, Mr. Reed.
Thank you, sir.
PM with provision 45 days. Yep. Okay, Me too. we'll see you.
Thank you, Your Honor. I'll make contact with Star and then, as you said, with Brittany to set up for the Zoom.
Yeah, what I'm going to do is I'm going to send everybody an email, which will include you, prosecutor, Officer Bridgman, and Brittany and Ginger, that basically says, this is what we're doing. We're going to get her assessed for ILC or him assessed for ILC. And then you just need to get in touch with him at the STAR program. And then I assume that the STAR program can accommodate us via Zoom. Most of them can. So we'll get it set up.
I'm pretty sure I've had arrangements out of Star before.
Yeah, I'm sure we've done it before.
But thanks for.
Good. See you, Jonathan.
Looking to pay as much as I can out of pocket before they can help. I also have been in communication with the Jewish Family Services and with Friends Indeed, and I also have been in contact with SOS. Her name is Angela Johnson. So I've been in contact with all of those people. However, I still have to pay off that balance in order to receive the help.
Yes, absolutely. Okay.
And
So
one last thing,
go ahead.
one last thing. I plan on filing my income tax sooner than later, so I can at least try and get an advancement to help with this balance. So yes, this is very stressful. I hate that I'm even here, but that is how I intend on paying this balance down and keeping it. I don't want to have to deal with this anymore. So
you know what, Miss South? I hate it that you don't even have a plan.
I
No,
do.
I'm kidding.
Yes, I do. Oh
I'm
my
kidding,
gosh.
Miss South. All right. So have you been in touch with your landlord regarding a
Yeah.
repayment?
Actually, so what I have been, I talked to Latasha and Ajane, and they told me to come down and I can make payment arrangements. However, I work midnights, so like right now I would be so asleep, and I typically don't get up until like late when it's time to make dinner. So long story short, again, I have been in communication, but I have not signed the paperwork, even though they told me to do that because they will work with me because they know that I am a hard worker and have been working. So, yes.
Miss South, I don't have a doubt about any of that hardworking or any of that part,
Yeah.
but with you. I don't know you, but it just seems I'm just listening to you. So get that paperwork signed so then
Yes,
that
sir.
they can talk to their attorney to try to see if they can get that formalized and get that entered with the court. Okay?
Understood. Yes, sir.
All right. So I'm going to adjourn this to January 23rd, 2026 at 1 p.m. That's an in-person hearing, ma'am. So you'll
Okay,
need to
I'll be there.
are you going to be really sleepy though?
You know what? I won't even go to sleep. So that's fine. I'll stay up.
Okay. I don't know. Maybe that works for you. I don't know. That doesn't work for me. But
It's
all
gonna be
right.
rough.
We'll see you
But I'll
then.
be there. All right. Thank you
All
so
right,
much.
Miss
You guys
South.
have an amazing day.
Thank you.
You do the same.
Thank you. Bye.
Haverhill on Clark versus Emmanuel Ware the third.
Good morning once again, Your Honor. Brian Butch, RP 662504 for the plaintiff.
All right. And Emmanuel's here. All right. How much is owing on this?
Judge, we're showing a balance of $10,860.60. We have court costs of $170 for a total of $11,030.60. I do not have a proposed payment arrangement in my file.
All right. All right, Mr. Ware, how are you intending on getting this paid?
I wanted to ask if I could get 30 days to get all the money together because I start work at U of M making 18 an hour. I start on the 19th, and my mom's gonna help me come up with the money. And if I can't get an agency to like help out, then my mom's gonna get a loan for like the remaining balance.
All right. So let me just ask you this. Have you your balance is rather high, but there are certain agencies that can help you out or may be able to help you out with at least part of it. But have you been in touch with any of those?
I came in contact with some of them, but they weren't really going for it. So still
All
looking.
right. So, but what you're telling me is you think you can have it paid in 30 days?
Yeah.
Okay. Have you talked to your landlord at all about a payment agreement?
We tried to do the payment plan, but they didn't trust it or something. So
They what? They didn't trust it?
yeah. So they just told me
Okay.
contact the
So,
agency. So
all right. So here's what I'm going to suggest you do. You either contact counsel or you contact your landlord. If you say you're going to get it paid in 30 days, likely they're going to want a good faith down payment on that because in 30 days, February is going to click in and the balance is just going to go higher. Okay.
yeah.
So see what you can do in terms of working with them. I'll adjourn this out to the 23rd, 2026 at 1 p.m. That's an in-person hearing. So you'll need to come down to the courthouse and then we'll see what we can work out on this. Okay, sir?
Yes, sir. Can you say the date
All
one more
right.
time?
Yes, the 23rd. Next Friday.
Thank you.
All right, thank you.
Thank you, Judge. I believe you're done with me. You and your staff have a wonderful day and weekend.
All right, thank you. You do the same, sir.
Thanks.
And I better call these. Haverhill on Clark versus De Leon, Haverhill on Clark versus Khalik, Muhammad Khalik, and Celine Townhomes versus Quincy Jones. These matters are dismissed on plaintiff's motion without. Ryan Martin versus Tamika Sims.
Your Honor, good morning. This is Martin Ryan, plaintiff. Appreciate you hearing my case this morning. This is a case for non-payment of rent. The rent to retain is $9,179. Court costs of $110 for a total balance of $9,289.
All right. And Ms. Sims,
Hi, Mr. Simpson.
how are you intending on getting that paid?
Well, actually, Mr. Simpson, me and my family are trying to relocate. And I had asked Mr. Ryan for an eviction notice to receive assistance months ago, and he never gave it to me. So therefore, that has made it get higher. I was in garnishment, unable to pay the full amount of rent. If I didn't work my full amount of hours, garnishment was still going to happen. I had health care through my job, which was $200 or something every 2 weeks as well. I informed Mr. Martin that I would not be able to get my balance down unless I received an eviction notice to get help from the agencies. I was just informed that an eviction notice to him would be costly, but it was real costly for me to figure out how
All
I'm
right,
going to come up with the rent, things like that.
let me
So we
ask
just
you.
want to move.
All right, so when are you planning on moving?
So right now I'm in the process of getting everything together. I would say by the 31st.
Okay, you're gonna try to be out the 31st. Okay, just so you know, Mr. Ryan has claimed a money judgment on this. So we'll have to deal with that. But if you're out by the 31st, or there's an agreement to be out by the 31st, maybe that can work. So what I'm gonna do in this case, that'll work at least in terms of possession. I'm gonna adjourn this out to the 23rd. 2026 at 1 p.m. That's an in-person hearing. You'll need to
Sir,
come
I
down to
have
the
a job
courthouse.
training. I have
Pardon?
a job training. That's a flight has already been paid for that day because I was hearing that being said and I was in fear of that. But
Then what you can do, ma'am, is you can submit a form to appear via Zoom.
okay.
But you or somebody needs to be down here on this.
Yes, sir.
All right.
All right, Your Honor, a question as well.
Thank you.
You mentioned the date was the 23rd at 1 p.m. Is that correct?
Yes, it is. 23rd, 1
All
p.m.
right. Would I be able to send counsel in my place on that date?
Pardon?
Would I be allowed to send counsel in my place on that date, or do you need me in person?
Yes, you can. Absolutely.
Okay, excellent. Thank you.
All right, thank you. Group 5 Management versus Antonio Braun and Group 5 versus Turbington. Those matters are dismissed on plaintiff's motion without prejudice. I don't know who Zoom user is. They haven't responded. Okay, maybe they're on to 10 o'clock. All right, that's it for my 8:30 call. And I'm going to stand in recess. We'll come back shortly and deal with our 10 o'clock call. Court's in recess. Lost it on county.
Disorderly and
Not guilty, I am. Coffee, I went and got coffee. I wanted hot water, and gave me lukewarm water, and then I bought coffee. And I got that.
1 second, Mr. Sorrell, please.
Yeah, okay, mute.
What do you want to say regarding bond?
My client is I'm supposed to bond, Your Honor. He promises to come back to court. He's anxious to resolve this matter.
Jeez. The allegation is he was making a scene in Culver's, telling employees he was going to kill and stab everyone in the restaurant.
That isn't true, Your Honor. It was
Sir,
not
Mr.
true.
Sorrell, Mr.
I did
Sorrell,
not, you know
Mr.
what?
Sorrell,
I have to be
please,
out today to go to,
please,
I want to talk.
please,
I have to go to
please.
probation today.
Please,
I-
sir.
and I- Everything's
Sir.
been going well. I did not do that
Sir.
over a cup of coffee.
Okay. I just told your lawyer what the allegation is.
Well, I need personal bond to get out and go to probation. Everything's been going well, Judge. I live in Taylor now. I was over here I had to come over here to see friends too. And yeah. Over a cup of coffee, I'm gonna do that. Yeah, right.
All right, I'm going to tell you the bond conditions first. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No contact with Woodhaven Culver's employees, no contact with prosecution witnesses. You cannot enter 23300 Allen Road in Woodhaven or any other Culver's restaurant. You're not to possess any firearms. You cannot possess dangerous weapons.
Good.
7,500, 10% is the bond.
What?
I will give you
Sure,
a
I
court
can't-
date of
You're gonna send me to
January the
county again,
28th.
man. I can't go to county. You understand
January
that?
28th
I
at
need-
10:30.
I need medicine. I can't go to county. I can't go to county, man. I need medicine. What are you sending me to county? I can't pay the
Put
bond.
medical on there, Heather.
I want a
Thank
personal
you.
bond, man. No.
Okay, Judge.
I want a personal bond, you asshole. What is up here? You never give me personal bond. You're an asshole, man.
All right, I'm an asshole. That's
You won't
okay.
give me personal bond.
All right,
You
let
have
him
to.
shut the thing off. Will you guys? I've had enough of
Sending me
this.
back to county.
Oh, wait a minute. That's it.
Judge, you want me to remove the camera?
Well, do I have another one with you guys, Wilson, or is that in here? Oh, yeah, you shut the camera off. Anya, Adriana, Barbara Wilson, 25W840825. Ma'am, your name?
Wilson.
All right, driver license expired. She stand me away from my reading?
She does, Your Honor.
Where's she been? Why didn't you show up on this, ma'am?
Your Honor, I know you've heard this reason many times, but it's true here. The bottom line is she didn't get notice, Your Honor. They sent it to her parents' house. Didn't know, or she would have came and resolved.
They handed her the ticket. It said to appear within 10 days. Did you call the court? Yes or no? Well, then come on. Don't play with us, okay? Or else you're gonna end up in jail. I don't want to hear it. You do that again, you bring a lot of money with you. $100 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed.
Can we get directly to her new address, Sean?
Yeah. Go ahead.
22576 West Road here in Woodhaven. 48183.
I'm sorry, 2256 West Road?
Yes,
Okay.
76, yes. All right. Woodhaven 48183. And her new phone number, if the court doesn't have it, is 734-925-3816.
All right, ma'am, I'm gonna give you a court date. Your court date's gonna be in front of Judge Hesson, January 28th at 11. You make sure you show up, ma'am. You understand? Can't be doing this. You get yourself in all kinds of trouble. Good luck. If you want a petition for a court-appointed lawyer, if you want a court-appointed going forward, you're gonna have to fill out a petition for one, okay? Jermaine Hall, Jermaine Sean Hall Jr., 25, G306346A and B. Name, sir? What do you have to say, Mr. He's missed at least three times. He thinks he's walking out of here with a personal bond too.
Well,
What happened? Was he in custody? Was he in the hospital?
no, Your Honor, he just made an honest mistake. He thought the court date was today versus yesterday.
Yeah, 3,000, 10%. You cannot leave the state. I'm not changing my mind. He's missed three.
You change your mind. Would the court consider 2,010%? He
Nope.
has $200.
Nope, I'm not.
He's got $220.
I don't care if he's got $220. I want 300. He's missed 3 times. He's not going to keep doing this. You want to keep delaying this until the day? That's okay. January the 29th at 9:15. You cannot leave the state. You cannot violate a law. You must appear in court as directed. Grow up, okay? Grow up. That's it. He'll let you make some calls. Be glad to let you make some calls to come up with money, but I'm telling you, I've had it with you. You understand what I'm saying? Good. Mr. Crawford, can I talk to you a second?
Seventh at 9, correct?
Yes.
Thank you, Mr. Dean.
All right, we'll be in recess. Mr. Florio, you are excused. We'll now take up the Eubank matter on the record in GW 2024 TR 643, State of Kansas versus Samantha Noel Eubank. Paul E. Dean for the state. Ms. Eubank, that is you up there. Can you click on your microphone or your volume? You're having the same problem I had a while ago. Except my problem was a little more complicated than just picking.
All right, I got it ready. Thank you, ma'am.
You do, yes.
Yes, that's
All
fine.
right. So, Ms. Eubank, what do you want to do about this charge of DUI dating back to October? You were going to look into diversion, and I think you got it, and now they're wanting to revoke it. Is that right, Mr. Dean?
Your Honor, it was. At this point in time, Ms. Eubank has paid the money that was past due. I think the diversion, I was just looking on the time frame. I believe that was at this point, that was the only reason why we were requesting a revocation. Failed to pay all court costs and fines, correct. So at this point in time, Your Honor, the state would withdraw its motion.
All right. The court will note that the state has withdrawn its motion to revoke diversion. Any reason why we can't close the case, Mr. Dean, at this time?
I don't believe so. That was the only reference within the motion, so.
All right, then Ms. Eubank, you are excused and your case is closed at this time.
Ms.
Thank you,
Eubank,
ma'am.
would
You guys have a good day.
You as well, but would you waive signature on the journal entry? Basically, it's just a document that says I withdrew the motion to revoke. Then it'll be filed in the record. All right, thank you.
Thank you.
Now you may go.
Bye.
Bye. We'll be on the record now in Miller, GW 2023, TR 365, State of Kansas versus Victor M. Miller. Paul E. Dean for the state. Victor Miller appears in person and pro se. You are Victor Miller, as your screen says, sir?
Yes, ma'am.
Very well. You are here on speeding 72 and a 50, driving while suspended. And that dates back to May 17th of 2023.
Benchmark was floating out there for a while.
We had a failure to appear for quite a little while. Well, for a little while, I won't say quite. How do you want to proceed at this time? You applied for an attorney last time and didn't qualify. Are you going to hire an attorney or represent yourself?
No, ma'am, I lost my job. The man that I'm working for, he had lied to you. I don't make no $4,000, what he told you. All I was making was $100. I told him why he get on there and told you that. And now it's gonna be hard on me. I lost my job, he quit me. And so I can't pay for nothing.
So you were the gentleman on here with your employer that was helping you orally fill out your application for attorney?
Yes, ma'am.
And now you're unemployed completely?
Yes, ma'am. He just left me. I don't know why.
All right. Well, no income at this time. How long have you been unemployed?
For about a week and a half.
Okay. And are you married or single, remind me?
I'm single.
And remind me, please, if you have any minor children?
I got 3 of them, but I can't see them. They won't let me see my kids, so I ain't got no. I don't know how to go about doing that. So.
Do they make you pay support for those children?
No, ma'am. No, ma'am.
All right. Well, at this time, if you've been unemployed for a week and a half, do you have any prospects of employment in the future? The
I'm
near
trying
future?
to. I'm trying to, Judge.
All right. Well, at this time, I'll find you now qualified for court-appointed counsel, and I will appoint Attorney Richard Paw. Is that right, Missy?
As far as I know.
Since it's a misdemeanor, call Mr. Paw. You have a pencil to take down his name and number?
Give me a minute. I got you. What is it?
Okay, his name again is Richard Paw, spelled Paugh, and his phone number is 316-303-0100.
Thank you.
And Missy's going to tell you your court date that you can share with him. When will he come back?
How
Yes,
far
ma'am.
do you want to go out?
Oh, 30 days or so, probably.
Probably
Okay,
that
you want
February 13th date.
February
Okay.
13th? Okay.
February 13th, you want him back at 9?
10.
10. All right,
Thank
you and
you.
Mr. Paul need to be back here February 13th at 10 a.m. by Zoom, but call him today and get started on him, letting him help you.
And,
Yes, ma'am.
and
Thank
Mr.
you.
And Mr. Miller, I don't want you to state anything one way or another about your driver's license status. Okay, I'm not trying to get you to make some kind of incriminating statement or anything.
Yes,
But I
sir.
just want to let you know that you've got a Tennessee driver's license. At least that's what I see in the file.
Yes, sir.
I can't look that up as easily as I can the Kansas driver's license status. All I'm letting
Yes.
you know is, and your Mr. Paul would be giving you the same advice, but my policy is generally if you can take the steps to get your license valid again, I generally offer an amendment to a lesser charge that doesn't affect future driving privileges. And that's generally what we do. I usually would then look at amending the charge down to no driver's license in possession, which at least in Kansas doesn't carry any additional suspension. So just letting you know, if that's something that you can do, you ought to look into that as well as talking with your attorney. So good luck to you, sir.
Thank you, sir. God bless you.
You may go at this time, Mr. Miller, but call your attorney.
I will. Thank you, Judge, so much.
Thank you.
Yes, ma'am.
Being in recess on Miller, we'll now, I think, not have another until 10. Is that right, Missy? You may
That's
go.
correct.
That's correct, Judge. And Judge, I hate to say this, and Mr. Miller, you're free to go. We're just talking
Okay, thank you.
sections of the docket. The state of Kansas does these driver's license hearings, and they don't ever coordinate them. They just give, and that's one thing that Clark Alban had today, but he had a whole slew of them. I've got one that's set at 10. They're set for 15 minutes. It's right here in town. I've tried to get coverage, but I wasn't able to get coverage, so I didn't.
Okay.
There's just a
Sure.
conflict I had no way to work around. But I know I've let Richard know he was going to be running late to begin with. I think most of the cases, him and we've already had discussions on them. I need to check on status with him. And hopefully we can, because I think several of them we already had set for plea or already had a plea worked out. We're just waiting to see if everything was completed that needed to be done.
So we may be a little late starting our 10 o'clock docket, it sounds like.
Yes,
All right,
that was my
10
long way of saying that, but trying to let you know that I tried to avoid this, and I didn't schedule this. I was just told
I understand how
where
that
you're going to be at when. So,
Well, we had one of our 10 o'clocks, JP Squire, there at the courthouse, James Patrick Squire, at the courthouse.
and actually, we could take him up right now because he was pro se, wasn't he?
Now he has Richard. He was, but now he has Richard. Mr. Paul.
Do we still have one pro se at 10?
We do. At 11 we do. We have no.
Oh,
strike.
11.
Like
Okay, I
that.
thought I saw.
Let me look. I may be saying out, that may not. Missy, how about that Kimberly Adams? She was 10
Yeah,
o'clock.
she's still pro
Thursday,
se, as far as I know.
but she's not here, so.
No, she's
Yeah.
not here yet.
All right,
Well-
well, we'll just kind of play it by ear, see as we need to.
Before I have to leave my office, I'll check in prior to 10 o'clock just to see if anybody's here early that we can maybe address.
I think Missy said we have some that took diversion. Was that this docket that they'd taken diversion?
Yes, both of them that were still on 11 o'clock for diversion it has been filed. Both of them have been filed.
So maybe that'll give us some carryover time.
Yeah, that'll definitely give us some carryover time because we just have 2 cases, and the Alexander, wasn't that one that we had already started the trial?
Oh, is that the one that we were missing something on?
Well, that's the one where he was trying to show his bank statements that I think, let me double check here.
Trying to prove somehow that he'd paid his insurance or the.
Right. And I said, just get it to us and we can verify it and I can dismiss it because that's an absolute defense if you had it.
Yes.
Yeah, come over. Yeah, so that's set for, it says bench trial, but we've really already taken the evidence on it. We were just, and I've given them let me check to see if, because he was right after the last hearing, he was supposed to get back to my office and make sure they had whatever they needed to verify.
Yes,
So I'll
because
check on that.
he said he had emailed proof, but the question was, why wasn't it in the file if he did?
Right.
So he was going to follow up. All right.
Well, and I think we'd come to the conclusion that we had a bad email address, and I don't know that he was using the correct one.
Oh, okay. All right. Well, we'll take a recess until we get another defendant here. And if you need to go, you need to go, and we'll pick it up when we get back.
I'll be back as fast as I can. Thank you, Judge.
You're welcome. Thank you.
Bye.
Bye. Court security, if you can hear me, I would request if you get anyone else down there, just put them in front of the screen so we'll know. Thank you.
Yes, ma'am.
Oh,
Yeah, I don't see, unless that's the individual just sat down in the courtroom, Judge. Or not.
I don't, this is Ron Florio.
The only one there at the courthouse
Yes,
so
I'm here.
far?
Oh,
No,
Click on your
we
microphone
haven't,
so I can hear you.
can you hear me or
Should be a
not?
little red microphone and start maybe. something
Your
that
Honor,
start-
actually, Mr. Davis,
Can't
Your
find it.
Honor,
There may be an officer that can help you there. So
Judge, can you hear us?
Judge, I don't think she can hear us for some reason.
Oh, there you go. You can see me. I lost you guys.
Do you each solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
yes,
All right, you're here today, Ms. Holmes, for a first hearing on a non-payment of rent case. Did you read the advice and rights form that was mailed to you?
yes, I did.
Do you have any questions about your rights after reading it?
No, sir.
Do you want to speak with a free legal aid attorney?
No, thank you.
All right, Mr. Drian, did you resolve this with Ms. Holmes?
Yeah, pretty much. I'm gonna go back and look at the paperwork after the fact, and if something is owed more back to her, then I have no problem getting in touch with her and paying her, whatever money's due owe back to her. There's a little bit of discrepancy how much she paid for first month and last month, but she's willing to pay a set amount of money, so we come to that conclusion.
How much is the back rent that you're claiming?
Well, it was $1,900. She had a security deposit of $750. Minus that with some other stuff, it was $1,500.
Okay, not counting the security deposit, how much is the back rent that you're claiming?
$1,900.
$1,900?
Yes. Okay.
And how about the court costs?
That was like 145, I believe. I forgot about that.
$145?
Yes, sir.
That's a total of $2,045. And Ms. Holmes, you agree that's what you owe?
No, sir.
No, we came out. Oh, sorry, sir.
Did you say no?
Yes, no, sir.
How much do you claim that the back rent is that you owe?
Well, originally when I moved in the place, I gave a security deposit of $1,500, but when I moved in, I was with my ex, and my ex gave the check that I no longer speak to, so I don't have proof of that. And he doesn't have a copy of it, so we came to the agreement of his $1,150. I told him I'll just pay him that just to get it over with.
Do you agree on that, Mr. Drian?
Yes, Your Honor.
All right. So you agree on 1,000, what was that? 1,150?
Correct.
Plus the 145 cost is $1,245. And you both agree on that, is that right?
Yes.
Yes.
All right, this will be what's known as the consent judgment for possession only. And Ms. Holmes, you have to pay that in full or move out by January 26th.
I'm already out of the place, sir. I'm no longer living there. I left before the time frame that he gave me.
Copy of the judgment will be mailed out to the parties. Since you neither of you have an attorney, the court will prepare the judgment to that effect, and you each have a good day, and thank you for resolving.
I have a question, sir. I have a question. How do I make this? How do I make this payment? Do I just send it to him the way I've been paying him, or do I bring it to the court?
No, you would pay directly to the landlord.
Okay, thank you.
All right, you have a good day.
You as well.
Your Honor.
From here.
Oh, and my screen went blank because I'm just done now.
Judge. Good morning, Your Honor. Michael M. Williams appearing on behalf of J. Ganesh.
And Mr. Williams, good morning. And you are Nathaniel Pierce?
Yes, Your Honor.
All right, I can't see you.
Sorry.
Mr. Pierce, raise your right hand. I'm gonna ask you to take your hood down. We're in court now.
Sorry.
It's all right. Do you solemnly swear, affirm, tell the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right. And Kayla Howerton is not here at this time. Is that right?
She was in the court and she was kicked out. She was driving, taking the kids to school.
All right. And you're here today for a first hearing on a non-payment of rent case Mr. Pierce, did you read the advice of rights form that was mailed to you?
No, Your Honor.
Do you have one there?
If it's in the court papers, I have the court papers in front of me.
Do you have the advice of rights form there?
Not entirely sure, Your Honor.
Judge, I have Kayla Howardson here now.
Pardon me?
I have Kayla Howardson here now.
I don't believe I have the form in front of me, Your Honor.
You say you have it?
I said I do not believe I have it.
All right, and Ms. Howardson, you're here now?
She has no audio still.
Can you hear me, Ms. Howardson?
Sent her a message to connect to audio, but I don't know if she's seen it. There's no other way to.
Ms. Howardson?
She still has no audio, Judge.
Ms. Howardson, come on.
Okay, now she has. Now she's just muted. There we go.
All right, Ms. Howardson, can you hear me?
Yes, I can hear you.
All right, Ms. Howardson, raise your right hand. Do you solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, self you got?
Yes.
All right, and you're here today, Ms. Howardson, with Mr. Pierce for a first hearing on a non-payment of rent case. Did you read the advice of rights form that was mailed to you?
Yes, I did.
Do you have any questions about your rights after reading it?
No, I didn't know if I should call to contact a lawyer or not, but no other questions.
Do you want to speak with a free legal aid attorney, you or Mr. Pierce today?
I'm not sure if that's the right. It's okay, no.
All right. Mr. Pierce, do you want to speak with a free legal aid attorney?
No, Your Honor.
All right. Mr. Williams, have you resolved this matter with the defendants here today?
No, Your Honor. We have a minor matter to take care of, and then we're going to need another hearing. And the minor matter is that we'd like to amend the pleadings to name Nathaniel Press, AKA Nathaniel Pierce, because apparently we got the name wrong.
All right, we're going to adjourn this then. It'll be on Zoom with the same password. I can't tell you the date and time. The court will let you know the date and time to appear. So we'll see you at the adjourned date. You each have a good day.
Thank you, Your Honor.
Thank you.
You're welcome.
Thank you, Your Honor. Have a good day.
You too.
This one, Judge, we have the plaintiff's attorney, but no defendant check.
This is the matter of Alfred Washington and Jennifer Hadley versus Shaquille Powell, 25-61250.
Yes.
Mr. Washington, good morning.
Good morning, Your Honor.
And Mr. Asphalt, are you there?
He's still muted.
Yeah, sorry, Judge, I am here. There we go. I am here, Judge.
All right, Mr. Asphalt, good morning. As you gentlemen know, this is on the docket for 8:40 this morning. Defendant Powell has failed to appear. It's now 9:02 in the morning. And Mr. Asphalt, you may proceed.
Yes, Judge, we are seeking a judgment, a default judgment of possession as well as a default money judgment. There's currently rent retained in the amount of $4,600, cost $264.39 for a total of $4,864.39. The defendant would have until January 26, 2026 to make that payment or a writ can issue.
All right, that default judgment for possession of money will be granted. You can submit your paperwork to the court for signing, and you each have a good day.
Thank you, Judge. Have a good day.
Thank you,
Thank
Judge.
you. Thank you. Mr. Asphalt, are you doing the 110 cases this afternoon?
I am. So I'll be back at it at like 10 o'clock, Judge.
All right, thank you. Oh, yeah, you have one at 10 also. Thank you.
All right. Thank you, Mr. Washington.
Thank you, sir. Do I just click out?
You are all set to leave, Mr. Washington.
After IOP, Your Honor, she is going to continue with aftercare. She was in sober living at Jordan House, but has since moved in with her mother. Your Honor, her mom lives in Willoughby, which is right down the road from where she's doing her IOP. It's a very convenient location for her. Her son, who has mental health issues, also lives there. She does also assist her mom with her 7-year-old niece because her stepdad is currently receiving hospice care. So she's trying to be there for her family, Your Honor. She's described her mom as her rock, so she's indicated it's a very good environment for her. So, Your Honor, we would like to ask the court for community control, allow Ms. Pache to continue doing the treatment she's doing. I have received many letters from Signature Health, Phoenix Counseling Solutions. I did email those to the court. She just wants to get this behind her, Your Honor. She wants to stay sober. She wants to continue what she's doing. She said the reason for her spiral, she did lose her husband around this time last year, and it was a very difficult time for her. She knows she made the wrong choices, and she just wants to do better herself, be there for her son, be there for her mom, and essentially be there for herself. Thank you.
Ms. Pache, what do you want to tell me?
Good morning, Your Honor. Everything Ms. Tomac said is true. I lost my husband a year ago, and I just fell into a deep depression. We were together 21 years. He was a cancer patient. I miss him dearly. I didn't have much support at the time because I had dedicated all my time to his medical needs, and I kind of put my own needs on the back burner, and one thing led to another. But since then, I have admitted myself into Ethan's Crossing. I successfully completed their detox. residential, their PHP program. From there, I went to sober living with the Jordan House, who also specializes in trauma, mental health, substance abuse. I currently attend IOP. I have a sponsor. I do peer support. I have counseling. Like, I have all the right things lined up finally. And I'm just my stepdad's.
I can see you.
Yes.
All right. And what is plaintiff's claim in this case?
Your Honor, this is a termination of tenancy action. The court should have before it a proposed consent judgment. I admit that it is a little bit dark, and therefore I wanted to read the terms into the record. My client would be entitled to enter an order of eviction terminating the tenant's tenancy if she does not comply with the community rules and regulations. Specifically, she's to remove the improperly stored outdoor items and shall mow her lawn, trim and weed on or before July 16th, 2026. She's to maintain the landscaping and general appearance of the property according to the community rules and regulations and pay all court costs to my client within 10 days of today. Should she fail to comply with any of the terms of the consent judgment, an order of eviction may issue immediately. The defendant waives her right to enforce the 56-day rule, and an order of eviction may issue more than 56 days from the date of the judgment without a hearing if the terms of the consent judgment are breached. Ms. Storrs does appear before you this morning without counsel and would be entitled to 3 days in which to revoke her consent.
Ms. Storrs, is all of that correct?
Yes.
Have you had an opportunity to speak with an attorney regarding this?
No, I haven't.
Would you like that opportunity, ma'am?
As long as I'm not evicted and all I have to do is maintain the property, then I'm okay.
Okay. Here's what I'm going to do on this. Because I have some question about entering this on the first day, but I'm going to adjourn this out to the 23rd. I understand the terms, and Mr. Landman, I don't have the judgment which was sent in any event before me, but I'm going to adjourn it out to the 23rd at what time? At 12 noon. That's going to give you an opportunity to speak with an attorney regarding this, should you so choose to do so. All right. I understand the terms that are being placed on the record in this case, and I would enter it, but I want to give you that opportunity to talk with someone regarding it. Okay, ma'am?
Okay.
All right. So I'll adjourn it to that date, understanding that there is this proposed consent judgment that's out there.
And Your Honor, I appreciate that. I will note for the record, Ms. Holm from our office is going to be appearing before you this afternoon. And she is actually hand delivering an additional copy because of the problem with the readability.
All right. Very good. Thank you.
Thank you. Have a great weekend. You too, Ms.
All right.
Storrs.
You do the same. Avalon Housing versus Damon Harris.
Good morning, Your Honor. Parissa Gazari appearing for plaintiff.
Yeah. Damon Harris. I have my two screens, which are my issue. They are not here. My staff has said they have not checked in. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Well, and this is well, hold on. Let me check this service. It's a first hearing. I got that. I do have that, but I don't know. I do have the mailing. Go ahead.
Okay, thank you, Your Honor. The rent to retain possession is $6,710, court costs of $132 for a total redemption of $6,842. Plaintiffs requesting entry of a default judgment for possession only with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested, writ issue in 10 days. Avalon Housing versus, is it Tangia? Marshall Palmer.
Carissa Gazari for plaintiff.
You don't have that person here. Marshall Palmer. No response, you may proceed.
Thank you. The rent to retain possession is $4,000. The rent to retain possession is $4,812. Court costs of $132 for a total redemption of $4,944. Plaintiffs requesting entry of a default judgment for possession only with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested with a writ issue in 10 days. Sparrowwood Apartments versus Brent Terry. That matter's dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. Have a good day.
You do the same. They're here. Oh, Mr. Terry?
Yes,
You heard that your case is dismissed?
thank you. I appreciate it.
All righty.
Have
You
a
take
good
care
day.
of yourself.
Yeah.
Court calls the case of Northville Crossing versus Jessica Bradshaw.
Good morning, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff. I'm
Is
here.
there- Okay, there she is. Okay, I need a camera, ma'am.
I'm
What is
trying.
the plaintiff's claim in this case?
With costs, Your Honor, $2,069.68.
All right.
1 second,
I'm
trying.
All right, Miss Bradshaw,
Yes, sir.
how are you intending on getting that paid?
Well, unfortunately, we had miscommunication when I had help last time I seen you. With Hawk, when they finally got to help me, the miscommunication was when I spoke with them and everything, I paid up my portion of the 1,600 and they said that they were going to pay into December. Well, that was the miscommunication. They did not pay into December. So I paid my mortgage that was in arrear. And that is why we are here. So that is why we are here. So now I have to figure out that. And now I have 2 months worth of rent to come up with.
Okay.
Instead of 1. So I paid
All
up my
right.
mortgage that was behind with December's rent. And yes,
Okay, so let me ask you this, ma'am. Between now and next Friday, how much can you pay on this amount?
next Friday I get paid again. I'm not sure because I've been sick for the last 3 weeks. I had 3 seizures and had the flu on top of it. So I've been out of work. So I did get sick pay. So I'm not exactly sure how much I will have. Right now in my bank account, I have $150. So I have that and whatever I get paid next week.
All right, so you're gonna pay something, we just don't know what it is. All right, I'll adjourn this to January 23rd, 2026 at 2 p.m. That's an in-person hearing. I suggest also that you may want to contact your landlord, see if you can work something out, or contact plaintiff's counsel, okay? Who's muted? Okay, hang on one second.
Sorry. Can you hear me now?
Yes, ma'am.
Okay, sorry about that. I can't miss any more work, obviously, with being out for so long. Can I do one of those form things like I did before?
Ma'am, you'd have to submit the Zoom request and we will consider it.
Okay, will do.
All right, thank you.
Thank you.
Northville Crossing versus Nicholas Buckland and Brittany Moore. You got either one? Moore, Buckland. They are not here. If you'd like to take the fall, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
We do, for the record, Rachel Dornbush, Palace Law, on behalf of the plaintiff, Your Honor, there's rent to retain of $1,921.44. Costs are $246 for a total due of $2,167.44. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested with the writ to issue in 10 days. I have a important call from another judge, folks. I'm going to take a brief recess and return this call.
Amy Coker. Is that her? Very
She's
good.
in the courthouse, but her attorney's not here yet.
We gotta wait for her
Oh.
attorney.
Okay, well, let's see if we have, Paul, all right.
This is the matter of a Mitri Gal.
No, 3,580.
3,580. You agree on that, Miss Taylor?
I'm doing well. How's everybody?
That's good. Good.
Doing well. Good.
Is my video not working? Let me try to go out and back in. Is it working or no?
Yeah, we're not seeing you, Julie.
All right. I'll be
I
right
think the little toggle on your camera is covered.
The toggle on my camera is covered. No, there's like a little picture of a camera on mine. I'll come right back.
Okay.
The city of Atlanta matter.
We'll go ahead and talk a little bit about that today. First, I'd like to start by thanking all of you for your civility and professionalism in getting to the point that you're submitting to me what is actually an agreed case management order with agreed dates. I'm sure you all know in your litigation practices that doesn't always happen with highly contested cases like these. And so I really appreciate it. It makes my life a lot easier. And frankly, I think it makes y'all's lives a lot easier. So I appreciate that. I'm going to start with counsel for DEPCOM just because they're the plaintiff in all of the cases and go from there. Is that Mr. Mason?
Your Honor, Bill Buhay here on behalf of DEPCOM. I am joined, Your Honor, by Joe Guarino, Joe Guarino and Chris Burke of the firm of Varela Lee Metz in Guarino from Tyson's Corner, Virginia, and also Arnie Mason.
We're talking about an.
I'll be honest.
The District Attorney's Office for the state, Ms. Potter. I am attending this hearing remotely. I appreciate your accommodation. I was called away on an emergency matter related to a medical issue with one of my kids, and so I appreciate your accommodating me being remote today. I'll also note for the record that the individual who might need to speak with Mr. Burke regarding probation matters and reporting instructions, including registry issues, is also attending this hearing by video. Her name is Teresa Carty. Mr. Burke, here's what's going to happen in the next few minutes. In a moment, I'm going to ask the state to provide me with either an agreement that the parties that there is a sufficient factual basis for whatever the agreed reduced charges are, or some factual basis from the state. Assuming that there is a factual basis, either by agreement or otherwise, then I'm going to swear you in, and Ms. Potter is going to ask you a series of questions to make sure you understand what rights you have and what rights you are giving up by entering this plea. You understand that, Mr. Burke?
Yes, ma'am.
Okay. Now, during this process, if you don't understand something or if you need clarification, you're free to ask Ms. Potter to clarify. You're free to ask me to explain, or you're free to step back and speak privately with your attorney. Do you understand that, sir?
Yes, ma'am.
Okay. Ms. Potter, let's start with this. Can you tell me I understand this is a non-negotiated plea in the sense that the parties have not come to a full resolution of the amount of time that they would present to the court, but that some aspects of the plea have been negotiated. Can you tell me what those aspects are?
Yes, Judge. Both counts are going to be modified to sexual battery. CGA 16-6-22.1. They both carry a 1 to 5 year sentence. And so we negotiated count 1, 5 to serve 3 years, balance on probation. Count 2, 5 years probation consecutive, which gives us a total of 10 to serve 3 years, with the remaining 7 on probation. Register as a sex offender upon release, get a psychosexual, follow any recommended counseling, and no contact with the victim, Ms. Perkins. And correct me if I'm wrong, Mr. Murphy.
Yes, as to everything, except there wasn't an agreement as to the time to serve. But yes, we agreed to the registry, which I think is required, the psychosexual evaluation, and the any recommended treatment and no contact.
Okay, thank you. Mr. Murphy, for purposes of resolving the case today, is Mr. Burke willing to stipulate that there is a factual basis for the 2 reduced charges of sexual battery in counts 1 and 2?
We do stipulate to a factual basis, Your Honor.
Okay, thank you. Mr. Burke, will you raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you, sir. You may lower your hand. Ms. Potter, if you'll go ahead with the colloquy, please.
Yes, Judge, thank you. Mr. Burke, I know I'm behind you, but you can see me on the screen. Can you see me kind of?
Yes.
Is that okay? Okay. At this time, are you taking under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you haven't taken today?
No.
Can you hear him okay? Or how old are you?
22.
And how far have you gone in school?
12.
So you graduated?
No.
No. Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Okay. Do you understand in indictment 25 SC 002-106? The state is modifying the 2 charges to sexual battery, which is OCGA 16-6-22.1.
Yes.
Okay, and do you understand those are both felonies, given the fact that the victim was under 16 at the time?
Yes, ma'am.
Okay. Do you understand that you have the right to plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial?
Yes, ma'am.
Okay. Have you gone over all of your rights with your attorney, Mr. Murphy?
Yes, ma'am.
Have you had enough time to speak with Mr. Murphy about all the facts and circumstances known to you regarding the charges in this case?
Yes, ma'am.
Okay, including any and all potential defenses?
Yes, ma'am.
And do you need any more time to discuss the case with him?
No, ma'am.
Okay. And Mr. Murphy, do you waive formal reading of the indictment?
So waived.
Okay, and do you waive any and all defects?
So waived.
Okay. And the state is not aware of any outstanding warrants on these on this indictment or these charges. Are you, Mr. Murphy?
I'm not aware of any, no.
Okay. Judge, will he be able to withdraw his plea?
No, because the matter is set on a trial calendar, I believe.
Okay. So, Mr. Burke, this is what's called a non-negotiated plea or a blind plea, which means the state's going to give their recommendation to the court and your attorney's going to give his recommendation to the court. And then the court is going to actually decide on the final sentence. Since it's non-negotiated and we're at the trial calendar, whatever Judge Krause sentences you to, you cannot withdraw it. As opposed to a negotiated plea, if you didn't like or want to go forward with the sentence after she announced the sentence, then you'd be able to withdraw it. But you cannot withdraw it here. Do you understand that?
Yes, ma'am.
Do you understand that this is a guilty plea which will permanently be recorded on your criminal history?
Yes, ma'am.
Okay. And do you understand too that the court can sentence you to a higher sentence than what the state has recommended?
Yes, ma'am.
Okay. These two charges amount to a total of 10 years. So you're looking at a maximum of 10 years in custody. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or violate any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Okay. And do you understand you're not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Okay. Are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Okay. Do you understand that by pleading guilty, you're giving up certain rights? And I'll list those out to you. That's the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. So essentially, by entering this guilty plea, you're giving up or you're waiving all those rights I just listed. Do you understand that?
Yes, ma'am.
Okay. Is anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Okay. And is it your decision to plead guilty because you are in fact guilty?
Yes, ma'am.
So how do you, an indictment 25 SC 002106, how do you plead to the modified charge of count 1 sexual battery?
That's, you have to just announce that you.
How do you plead?
Guilty.
And count 2 sexual battery 16622.1 as well. How do you plead to that count?
Guilty.
Okay. This guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you have only a limited right to appeal this guilty plea conviction? For these felonies, you have 4 years from today, or you've got 30 days from today to file a direct appeal, and you have 4 years from today for this felony charge to file what's called a habeas corpus petition, and that challenges the voluntariness or constitutionality of what's going on here today. So those are 2 time limits that you must be aware of. Do you understand?
Yes, ma'am.
Okay. Thank you, Mr. Burke. That's all I need from you. Judge, as far as I am aware, Mr. Burke does not have a, the only thing I would like to add is, given the fact that the DNA results are still pending, and we were on a trial calendar. The court or the state has modified or reduced this to sexual battery. The victim is okay with this sentence, as she was ready to testify, and she was 13 years old at this time. Given all of those facts, Judge, we ask that you accept the 10 to serve 3 recommendation from the court. And at the time the court feels it's convenient, the victim, I don't believe the victim is on, but my advocate, Ms. Kristen Clark, is on, and she has a impact statement that the victim wrote.
Okay, and now is the appropriate time for me to hear that victim witness impact statement. Ms. Clark, are you there?
Yes, Judge. My camera is going in and out, so I'm not going to turn it on.
Don't worry about it. If
Okay.
you'll do me a favor and just start by stating and spelling your name and role, and then the name of the victim, and then read me her statement.
I am the victim witness advocate. My name is spelled CHRISTEN, last name CLARKE. And I am reading the statement on behalf of Shania Jenkins. It's spelled SHANIYA Jenkins, JEKINS. And it states, Dear Judge, I was 13 in 2023. I was taken advantage of. I was touched inappropriately, and my body was touched in ways that I can't talk about because it was so bad. Every waking moment of my life, I think someone is out to get me. The defendant has caused me so much pain. I have issues with sleep because every time I close my eyes, I can envision what the defendant did to me. The defendant placed his private part somewhere he knew it did not belong. I am still traumatized physically and emotionally. The defendant took away my childhood and innocence. I always blame myself for what happened. I'm always angry and I don't feel safe around men. I hope one day he will realize the pain that he has caused me and my mom. I remember having nightmares and crying every day. I want the defendant to know I have very bad PTSD and really bad depression because of what happened to me. I'm putting my life back together slowly, and Judge, I'm doing better in school now. I pray I'm the last victim, and I hope the defendant does not ever get to do this to any child ever again. Thank you, Judge. Sincerely, Shania Jenkins.
Thank you, Ms. Clark. Mr. Murphy?
Thank you, Your Honor. Your Honor, I'll first say there was a lot of negotiation that went on with this, and I appreciate the time and effort of Ms. Potter in taking a very hard look at this case and agreeing to reduce it to the sexual battery count. I understand there was the DNA issue, but there were also some significant mitigating factors involved. Mr. Burks had just met the victim the day before. We know that it is not a defense, but he was given a different age by her, and then she came to his home with some friends the next day. So he takes full responsibility for his actions, but I do want the court to know that there were some significant mitigating factors that also go in to making sexual battery seem a much more appropriate charge that fits the facts of the case, fits the circumstances that were there, and fits the investigation that was done after the fact. Mr. Burks is 22 years old as he stands here before you, Your Honor. He is a lifetime resident of the Atlanta area. He went to North Clayton High School. He did not finish his senior year, but he is currently enrolled in a GED program as he stands here before you today. He also works full-time for Amazon in addition to that. He has never been in trouble before, Judge. He doesn't have a criminal history. So this was something that, was out of the ordinary for him. And I think he would tell you he certainly did not want to harm anyone and is here with a significant amount of remorse and contrition as he stands here before Your Honor. When I first began negotiating with Ms. Potter, I did from the outset ask that she reduce this to sexual battery, and I did with a very straight face go to her and tell her that I thought probation was appropriate for the case for a negotiated plea. She obviously objected to that, and we're here with an understanding of what we're doing, Your Honor, but I do want the court to know why I went to her with that, and it was because of the issues with the underlying case, the facts of the case, the lack of a criminal history by Mr. Burks, and the significant support in the community and family that he has. I don't know if you can see the people in the courtroom, Your Honor, but I know you've seen in the past the significant number of people that come to court with Mr. Burks every time we come before Your Honor. His mom and dad are both here. His brother's here. His brother's girlfriend's here. His sister's here. His partner is here. Judge, she is actually going to be giving birth to a child expected on August 11th of this year, Your Honor. And all of those people are here to show support for Maurice because they love Maurice. And, despite knowing these allegations against him, they stand by him. They know everything about this. They are all fully apprised of the case, know everything about it, and make sure that they are here to show up and support him at every possible opportunity to do so. Based on that, Your Honor, we are tendering the guilty plea. We do not have any objection to the full sentence being 10 years. We do not agree with the 3 years being appropriate in the case, Your Honor. We think given all the circumstances that was significantly more. I will say after we initially went to probation, Ms. Potter had a higher offer than she has come to the court with today. We did come forward and ask to do a negotiated plea at 10-1. We were not able to get there today. So we are asking the court for that. That is the sentence we are asking the court to pronounce. We do not have any objection whatsoever to the registry. I think that is required given the subsection that the plea is under on the sexual battery statute. We have no objection to a psychosexual evaluation. We have no objection to any treatment that is recommended that he will undergo diligently and be ready to do. Your Honor, we would ask if the court would consider sentencing him under the First Offender Act, given his lack of a criminal history. He does not have any prior sexual battery charges. And for purposes of the First Offender Act, a second sexual battery conviction would prohibit him. But given that he has.
Mr. Lynch, how old are you?
Just turned 44.
How far did you go in school?
Graduated high school.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
If you enter a plea of guilty to this charge, I'm not going to sentence you today. I'm going to set this for sentencing in about 30 days. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. Looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Helbling before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of child endangering. It's a first-degree misdemeanor punishable by up to 180 days in jail and a $1,000 fine. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. They have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count 3, that on or about July 30th of 2025, defendant Anthony Lynch, who used inappropriate discipline by grabbing a minor child around the neck. This was at their home in the city of Lebanon, Warren County, Ohio. Mr. Lynch is the live-in boyfriend of the mother of the child, who is Nikayla Trammell. She's 13 years old at the time of the incident.
Anything on those facts, Mr. Helmling?
Nothing other than she was also charged in this, Your Honor.
Mr. Lynch, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes.
You understand the rights you're giving up by entering a plea?
Yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Mr. Helbling, you wanted to be heard on the issue of bail?
Yes, Your Honor. I've had a chance to speak to not only my client, but also Ashley, his girlfriend, he does have a lot of support at home. I spoke to him about the alcohol usage, and he understands now that he's been in there for a week. I think that was an eye-opener for him, Your Honor. He wishes to let the court know that he is sorry about that. He is remorseful about that, but he really needs to get back to his job at Kentucky Fried Chicken. He's been there for a couple years. Although he might not make a whole lot, it's enough to get the bills paid. And this has really put him in a financial dire strait this week.
Mr. Harris, state a position on it?
I know the court had ordered no alcohol, and I think that was the issue on this. I think there is some indication from my knowledge of this that he has been had an alcohol issue, and that might have precipitated some of this as well.
All right, I am going to release you, Mr. Lynch, on your own recognizance pending sentencing. You need to come back up here. You're going to be released today. I want you to come back up here, fill out the paperwork for the PSI later today. We'll see everybody back for sentencing in about 30 to 45 days.
Thank you, Your Honor.
All right. What's that? Yes. Next is the case of the state of Ohio. Case number 25CR43033. Present before the court is Ms. Borges, represented by Mr. Helbling, and we have Mr. Harris in the prosecutor's office. We're here today for a pretrial, but it's my understanding Ms. Borges is going to be entering a plea of guilty to 1 count of illegal conveyance, 1 count of possession of criminal tools, and we're going to set this for sentencing. Is that accurately stated?
Yes, Your Honor.
Ms. Borges, how old are you?
57.
How far did you go in school?
9.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
I take a lot of medication.
Let me ask it this way. Are you taking anything that would interfere with your ability to understand
No.
what we're doing here today?
No.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today. Instead, I am going to conduct a level 2 pre-sentence investigation. I'm going to set this for sentencing in about 8 weeks. When we come back here, my plan is to put you into our community control program. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes.
Did you review this with Mr. Helbling before you signed it?
Yes.
Are you satisfied with the representation you've received in the case?
Yes.
You're going to enter a plea of guilty to 1 count of illegal conveyance. This is a 3rd-degree felony punishable by up to 36 months in prison. Possession of criminal tools is a 5th-degree felony punishable by up to 12 months in prison. If I were to send you to prison because you violate the terms of your community control, then the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes.
Mr. Harris?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count 1 and 4, that on or about September 14th of 2025, Lebanon Correctional Institution, Warren County, Ohio, Michelle Borges conveyed drugs being buprenorphine into the prison, this being 49 strips wrapped in cellophane. This was intended to be passed to her son, Henry Borges, who was an inmate at the time.
Anything on those facts, Mr. Helbling?
Nothing on the facts, Judge.
Ms. Borges, did you hear those facts?
Yes.
Do you admit they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yes.
Which plea?
I'm guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. You need to go back down to pretrial, fill out the paperwork for the PSI. We'll see everybody back here in about 8 weeks.
Thank you.
Thank you, Your Honor.
All right, we do have Mr. Rogers just arrived.
Oh, I did not know.
no criminal history, he would be eligible for that. We have talked about the carrot and the stick of that at length, and he understands that and has absolutely no intention of ever being before your honor or any other judge ever again once he puts this situation behind him. So that is what we would ask your honor, and Mr. Burke would also like to address the court as well.
Okay, before I hear from Mr. Burke, Ms. Potter, does the state have any objection to the court's consideration of that first offender?
Yes, Judge, we would object. And that is not something we even talked about during any of our negotiations.
Okay. Mr. Burke?
Your Honor, I thank you for allowing me to speak. I take responsibility placing myself in a situation I should have avoided. And I understand how serious this has been. This is my first offense, and this experience has been a wake-up call that has caused me to reflect deeply on my decisions. Since then, I have been focused on doing better. I am working a full-time job, enrolled in school, raising a 1-year-old, and preparing for another child on the way. I respectfully ask the courts to consider an alternative sentence to allow me to continue this progress while still held accountable. Thank you for your time, Your Honor.
Thank you, Mr. Burke. Mr. Burke, I just have, yes, ma'am, Ms. Potter?
Sexual battery is not eligible for first offender either, under 4260.
That's one of the reasons I asked you, because I wasn't sure, but I thought that perhaps it was not. So thank you for clarifying that, Ms. Potter.
Yes, Judge.
Mr. Burke, I have a few just follow-up questions for you, and it's mostly just to spot check what you've already been asked by the state. But you understand that you have a right to plead not guilty to these charges, correct, sir?
Yes, ma'am.
And do you understand that you have a right, if you plead not guilty, to have a trial with a jury?
Yes, ma'am.
And do you understand, sir, that at a trial, you would be entitled to be represented by an attorney, including one at no expense if you couldn't afford one?
Yes, ma'am.
And do you understand that at a trial, your attorney would be allowed to ask questions and to challenge the evidence that the state offered?
Yes, ma'am.
And do you understand that at a trial, you would not be required to testify as you're doing now?
Yes, ma'am.
And you understand, Mr. Burke, those questions that I've just asked you and most of the questions that Ms. Potter has asked you are about important rights that you have that you are giving up by entering this plea.
Yes, ma'am.
Thank you, Mr. Burke. So it appears to me that Mr. Burke has an understanding of what his rights are and that it is his intention to waive those rights and enter a plea. And so I will accept his plea as knowing, voluntary, and intelligent. And the decision-making process for how to sentence in a case like this is not an easy one. I suspect it's the same reason that the state and the defense weren't able to come to an agreement, because the nature of the offense to which you have admitted is so concerning and bothersome and problematic in our community. But I'm also faced with a young person who's not previously had legal difficulties, who has taken responsibility for those actions, and who has offered some evidence of mitigation, the extent to which, whether it's legally valid mitigation or not, but certainly factors that would have been a matter for consideration if the case had gone to trial. And so ultimately the real question, although Ms. Potter mentioned to you that the court does have the authority, and you indicated you understood that, to sentence you anything up to the maximum that's allowed by law, which would be 10 years in custody, the court isn't going to do that. Really, the choice the court is making is between the 1 year that your attorney is seeking and the 3 years that the state is seeking. And under the circumstances of the case, given the lack of criminal history and the responsibility, the fact that Mr. Burke is here and is taking responsibility for his actions, I think I am inclined to err on the slightly lower side of that. And so what I'm going to do is sentence Mr. Burke on count 1 to the reduced charge of sexual battery under OCGA 16-6-22.1. to 5 years to serve 18 months in custody, and the balance to be served on probation. As to count 2, on the reduced charge of sexual battery in case number, as in OCGA, reduced charge of sexual battery in OCGA 16-6-22.1, I'm going to sentence Mr. Burke to 5 years of probation. Count 2 will be served consecutively to the sentence in count 1. In count 1, after the 18 months, the balance of that will be on probation. As we have already discussed, Mr. Burke is required to register as a sex offender, and he will be required to undergo a psychosexual evaluation and comply with any treatment recommendations that arise from that. And I also require that he have no contact with the victim. Mr. Burke, I do want to caution you and your family who've been so supportive of you that sometimes it happens that family members and friends have contact with the victim, thinking they're helping their family member. They're not.
Also been employed, going to school and taking care of my children. There hasn't been no mishaps as far as me not making it to court, Your Honor.
Mr. Rogers, your record is terrible. Your non-compliance with the prison rules, also terrible. We've had our bouts while you've been on pretrial. And I'm a little skeptical that this case is going to come out very good, but I'm willing to give you the opportunity for that to happen. So I am going to put you on 3 years of community control, basic probation. I'm going to impose upon you the standard rules of probation. Makes sense to transfer this up to Trumbull County where you live. However, we got some business to take care of before then. So what I'm going to do is I'm going to sentence you to 100 days in the county jail. I'm going to credit you with the 26 days that you have already done, and I'm going to stay the imposition of the jail. That means I'm going to put it off until March the 18th at 1 o'clock. So you're going to have a meeting with your probation officer on March the 18th at 1 o'clock. We'll put it in the afternoon so that you're not late. If you have a zero balance on all of your fees and your costs, and you give us a positive drug test or a negative drug test that day, then we're going to suspend the jail days and send your case up to Trumbull County for supervision. If you don't have a zero balance, or if you test positive for alcohol, weed, anything else, then you're going to go to jail. You're going to do the 74 days or so, and then we're going to transfer your supervision up to Trumbull County. Do you understand that?
Yes, sir, Your Honor.
I'm not going to impose a fine. I am going to impose the costs upon you. It is a term of your probation that you are not to be on the grounds of a prison, jail, any place that they hold inmates. You're not allowed to be on the grounds of that unless you're an inmate. So don't go visit anybody at the jail or at the prison. And we have 26 days of jail. If you violate the terms of your supervision or you leave the state without permission, I can sentence you up to the maximum penalty in the case, which is 12 months in prison. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the cost, they'll all be provided to you without charge. Good luck to you, Mr. Rogers.
Thank you, Your Honor.
Thank you.
Jocelyn Diamond.
Rachel Dornbush, Pellets Law on behalf of the plaintiff.
You got it. I'm sorry. Ms. Davis?
I'm here.
Didn't light up. Oh, there she is. Okay. All right. What is plaintiff's claim in this case?
With costs, Your Honor, $2,218.94.
And ma'am, how are you intending on getting this paid?
400 by Tuesday, and then we're gonna call and make arrangements.
We could have 400 by Tuesday, and then if possible, we can call to make arrangements.
All right. I'll give you the opportunity to call the office or call the attorney's office to see if they're interested in making arrangements. You said you can pay the 400 by the 20th?
Yes.
All right. So pay 400 by the 20th. Have you contacted any agencies regarding getting assistance?
I've been in contact with several agencies for assistance for various things. So right now, I'm just working with a couple different agencies for any resources that they have.
All right. I'll give you an opportunity to call what agencies you can, like Hawk or SOS, to see if there's something that's available to you. You pay the 400 by the 20th. I'll adjourn this matter out to January 23rd, 2026 at 2 p.m. That's an in-person hearing, so you'll need to be down at the courthouse. Okay, ma'am?
Okay, thank you.
Thank you. Northville Crossing versus Daniel Glosky and Michael Glosky. Michael or Daniel Glosky? There's no response. You may proceed, Mr.
Thank you, Your Honor. There is rent to retain of $1,728.46, costs of $246 for a total due of $1,974.46. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the
Can you
plaintiff
hear
by
me?
default. Okay, hold on. Who are you?
Sorry, the phone was muted. Michael Goloski.
Okay. You got him. Okay. Now I hear you, sir. All right. The plaintiff's claim is that you owe $1,974.46.
Yes, I do apologize. I've never been late on rent, but it's been a struggle because I was denied unemployment, and I do have $800 today.
Okay.
And I also have some money coming next week. It just hasn't posted to the account. It's an investment that I had to get into so I can get this paid up. I should have that available next week. I even tried to get it expedited, but they can't, unfortunately. So.
Okay, so you can pay $800 today.
Yes.
And then are you going to be able, once that comes through, to pay the balance off, or?
Yes.
Oh, okay. So here's what I'll do. I'll indicate you're going to pay $800 today, and then possibly the balance by next week. All right, I'll indicate that in the file. I'll adjourn this out 1 week to the 23rd, 2026 at 2 p.m. Okay? That's an in-person hearing, so you'll need to come. If everything's not paid, you'll need to come down to the courthouse.
But if it is all paid up, I don't have to?
Yep. You just have to make sure you check and make sure everything is all paid.
Okay, that's the goal, to get it paid up, so I'm not late ever again. I do apologize. It's just.
No, understood, sir.
Okay, thank you so much.
Thank you.
Okay. All right.
Northville Crossing versus Jose Gonzalez Ramos and Christina Gonzalez. Gonzalez Ramos, Christina Gonzalez. No response. You may proceed, Mr.
Actually, you know what, on this one, Your Honor, could we adjourn this one for 1 week?
Yes, absolutely. January 23rd, 2026, 2 p.m.
Thank you.
Northville Crossing versus Tony Rogers. She was here. Tony Rogers. I'm not picking her up on my screen, but you say she's here.
Yeah, the camera looks like it's facing the ceiling.
Oh, gotcha. Tony Rogers. She's there, but I'm going to pass this one briefly. Valley Ranch versus Demetrius Jenkins.
Rachel Dornbush Pallets Law on behalf of the plaintiff.
Demetrius Jenkins. You have.
Yes, I'm here.
Okay, there you are. Okay, we need to turn your camera on. What is plaintiff's claim?
With cost, Your Honor, $4,313.32.
And sir, how are you intending on getting this paid?
I'm working on getting the funds together to get it paid by next week.
Okay. So how much do you think you're going to get everything paid by next week?
That's my hope, is to get everything paid by next week.
Okay. Do you have anything now that's you can pay?
Yeah, I can put 200 down today.
200?
Correct.
Okay. Pay the 200 by the landlord. Then I'm going to indicate that you're hoping to have a balance by next week.
Correct.
I'll adjourn it out to the 23rd, 1 week from today, 2026, 2 p.m.
Sounds good. Thank you.
And that's in person. Thank you, sir.
Yes, unless I get it paid off, obviously. Correct.
Yes, but everything's got to be paid.
Yeah.
Okay. Thank you. Arbor Woods versus Brittany LaFloria.
Rachel Dornbush Pallets Law on behalf of the plaintiff.
But I saw her.
Yes, I'm here.
Oh, there she is. Okay. All right. What is plaintiff's claim?
Well, Your Honor, in this one, the case before the court this morning is actually what might be
termination.
Yes, it's a termination, but it's a companion case, I suppose, with an action that is scheduled for a hearing this afternoon. And we had previously adjourned that matter to finalize an agreement, which we have since finalized, and it has been sent over to the court this morning to Ms. Hartwick. I would defer to the court, Your Honor, regarding.
So she has another case this afternoon.
Yes, and that case is resolved, and the entry of the agreement in that case would warrant a dismissal of this case. And so I don't know if Your Honor would prefer to call the afternoon case now, and then I can dismiss this case on the record, or adjourn.
Yes, I'll do it. I've got that case now in front of me, and that is Arbor Woods versus LaFloria, that being the case ending in 4421.
And yes, Your Honor, so an agreement was forwarded to the court that has been reviewed and signed by both parties. It is a consent order for conditional dismissal, indicating that the complaint for non-payment of rent is conditionally dismissed. The court shall retain jurisdiction for enforcement purposes. Defendant's counterclaim is dismissed with prejudice. It acknowledges a rental balance due through January 31st, $6,722.46. It contains an agreement that defendant is going to vacate the leased premises on or before January 31st, 2026, and will be deemed to have vacated when the keys are returned to plaintiff. It indicates that so long as defendant vacates as agreed and pays a sum of $3,361.23, which represents half of the total balance currently due, along with the return of the keys, plaintiff agrees to waive the other half of the rental charges due and owing. It indicates that if defendant fails to vacate or pay as agreed, then plaintiff may file an affidavit of non-compliance for reinstatement of the complaint for non-payment of rent, entry of a default judgment, and issuance of an order of eviction, which shall occur immediately, simultaneously, and without further appearance of the parties. Defendant's security deposit of $500 will be handled pursuant to the Landlord and Tenant Relationships Act. and that any waivers referenced in this agreement do not include any damage to the premises above normal wear and tear. So that might still be sought if such damage exists, and we won't know that until possession is recovered. It indicates any waiver by plaintiff of any term or condition contained herein shall not be construed as a waiver of any other condition. Finally, Your Honor, it indicates that the 56-day rule pursuant to MCR 4.201M and the 14-day provision pursuant to MCR 2.612C are waived. So as indicated, Your Honor, I have signed, Ms. LaFloria has signed, and we've now presented that to the court for entry.
All right. And she's been apprised of her right to the court.
Your Honor, I apologize. I did not specifically advise Ms. LaFloria of her rights, and I'm happy to do so unless Your Honor wants to.
No, I'll take care of it here. All right, Ms. LaFloria, is all of that correct?
Yes.
Okay. Did you have any questions regarding this conditional dismissal?
No.
All right. You understand its terms?
Yes.
All right. You have 3 business days to think about this. If you believe that there's some right you didn't assert, some confusion or mistake on your part, or some other reason why you think that this court should set that conditional order dismissal aside, you'd have to file a motion within 3 business days of today's date. That doesn't mean that the court would set it aside, but you have that opportunity to file that motion. You understand that, ma'am?
Yes.
Okay, very good. The court will enter the conditional order dismissal, the court being satisfied with its terms. So that's on case, so that the record is clear, on the case ending in 4421. And pursuant to that, based upon what plaintiff has represented, the case ending in 4812 will be dismissed.
Thank you.
All right.
Thank you.
Thank you, Ms. LaFloria. Good luck to you.
Thank you.
Arbor Woods versus Angela Bogart. Angela Bogart. I do not see her either. They're not here. You may proceed.
Thank you, Your Honor. There is rent retain of $1,395.19. Costs are $186 for a total due of $1,581.19. It asks for a default possession only judgment with right to issue after 10 days.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested with a writ to issue in 10 days. Arbor Woods versus Matthew Bell. Matthew Bell. I don't see him. You don't have him checked in.
No.
All right. You may proceed.
Thank you, Your Honor. There's rent to retain of $989.19. Costs are $186 for a total due of $1,175.19. We'd ask for a default possession only judgment with written issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Arbor Woods versus Flora Boone. She is here. Hello, Ms. Boone. She's muted. Okay, but I do see her.
There I go. Thank you.
Okay.
Aye.
All right. What is plaintiff claim?
With costs, Your Honor, $1,492.58.
All right, Ms. Boone, how are you intending on getting this paid?
I can pay about the 28th, I think.
You
But
can
I
pay it all
thought, I was confused because I thought the money that I owe for this actual case, I paid it. I paid it January the 5th. And then they filed me January 6th, so I was confused because I know I still owe January, but I paid December.
Yes, Your Honor, the amount that was paid was $1,782, which would have cured the December balance, but it wasn't paid until after January came due. So
got it.
defendant is correct.
Okay.
Just January now that's due.
Got it. Okay. You got that?
Yeah.
Okay. So you think you can get that paid by the end of the month?
Well, yeah, actually, let me see. I get paid on the 28th, but it'd be like at night. So
Okay,
I can have it in by Thursday morning on 29th.
All right, here's what I'm gonna
But
do,
probably
ma'am.
before.
Okay, I can't adjourn it out to then, but what I'm gonna
Okay.
do is I'm gonna adjourn it to the 23rd next week, 2026, at 2 PM. I'm gonna suggest that you contact.
Can't hear. It's breaking up a little bit.
Pardon?
Oh, it was breaking up a little bit. I'm sorry. Go ahead.
Okay, I've adjourned it out to next week at 2 PM. And what I'm
Okay.
gonna suggest is that you contact the plaintiff's counsel's office to arrange either a consent judgment or a conditional order dismissal, which will get you to the end of the month.
Okay.
Okay?
All right. Thank you.
Thank you.
Okay. Bye-bye.
Arbor Woods versus Jennifer Carroll. She is. Jennifer Carroll. She's there.
I'm here, Your Honor.
All right. I'll need a camera on, and also Linda Carroll. All right. What is,
not here. All right.
What is plaintiff's claim?
With costs, Your Honor, $4,193.
All right. Ms. Carroll, how are you intending on getting that paid?
Okay. Here's the thing. I have my receipts for this year, and I have done the math, and I feel like I only owe like maybe $1,450. There's been some issue apparently with somebody else in the trailer park has the same address. So there's been things posted wrong, and I don't even know.
Ma'am, have you gotten a ledger from the office?
Yeah.
Okay.
And
And you've
that is
gone through
how I
that,
was-
you've gone through that ledger with your receipts?
Yeah.
Okay, so here's what I'm gonna do. I'm gonna adjourn it out to the 23rd, 2026, 2 PM. That's an in-person hearing. You'll need to send a copy of the receipts and the ledger, both to the attorney for the plaintiff as well as the court, so that we can attempt to try to resolve this short of a judgment or anything along those lines, if you think that you paid.
Okay.
All right?
So how do I do that?
Miss Carroll,
What do you mean, how do you do that?
I've got your phone number. I know you called yesterday wanting to discuss the matter, but we couldn't reach a resolution before appearing today anyway.
Okay.
And so I've got your phone number. I'll reach out to you and I can give you some direction on how to get me that documentation so we can review what you've got and see if we're in agreement with respect to what's owed.
Okay, and then how do I send it to the court?
Your Honor, if it pleases the court, once Miss Carroll sends it to me, I can forward it on.
Okay, very good. We'll handle it that way. Okay, Miss Carroll?
Okay, so at a Friday at 2 p.m.?
2 PM, ma'am. Yes, ma'am.
All right, thank you.
Thank you.
Have a good weekend.
You do the same. Arbor Woods versus Daryl Corley. And Stephanie Corley. Daryl, Stephanie Corley? I don't see them. No response. You may proceed.
Thank you, Your Honor. There is rent tuition of $564. Costs are $242 for a total due of $806. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Arbor Woods versus Latia Davis. There she is.
Good morning.
Good morning, Miss Davis. All right, what is plaintiff's claim in this case?
With costs, Your Honor, $3,706.55.
All right, Miss Davis, how are you intending on getting that paid?
Well, I was coming to bring 2,000 to him on the 23rd, Your Honor, and then on the 30th, I can pay the rest.
So you're gonna bring 2,000 on the 23rd?
Yes, sir.
Can you do that early in the day?
I don't get off work until 5. I usually just put the money order in there.
Okay,
Drop
so
out.
here's what I'm gonna do then. I'm going to adjourn this to the 23rd, 2026 at 2 PM. That's an in-person hearing. You'll need to be here. But what I'm going to suggest that you do is contact the plaintiff's counsel and see if something can be arranged for a conditional order, dismissal, or the like to get this resolved.
Okay, so me coming in the 23rd with 2,000 is a problem, or I'm not understanding this. I'm sorry.
No, it won't be a problem at all. It's just that it won't be paid prior to the hearing.
Oh, so basically I need it paid in the morning before the hearing.
Right. If you paid before the morning, then you'd still have to be here, but we'd be looking at a different balance and a way of resolving it.
Okay, I see what you're saying, sir. I get it.
You follow me?
Yeah.
Okay. But in the interim, I've adjourned it out the week. You can call Ms. Dornbush and see if you can arrange to have either a consent judgment or a conditional order dismissal to get it paid, because you've got a plan in place to get it paid.
Yes. I'm just, after the holiday, I'm just a little short. And I'm
Aren't we all?
pay it.
All right. So go ahead. We'll do that. We'll do it this way, and just make sure to contact the attorney for the plaintiff. Okay?
How do I
For your
get in
landlord.
contact with her, sir?
Look at the paperwork that you have, and you'll see a phone number on there.
Okay, at the bottom of the 248 number.
Yes.
Okay, and I need to talk
And
to
the
her.
attorney is Miss Dornbush.
Miss Dornbush. Okay, I will give her a call right now, sir.
Well, don't do it right now. She's on the record with me.
Oh, I'm sorry. I'm sorry.
All right.
Thank you, sir. Y'all have a good day.
She won't answer. All right.
Okay.
Okay.
All right.
All right. Thank you, Ms. Davis.
Bye-bye.
Arbor Woods versus Shakori Davis. Shakori Davis. Yeah, I'm down to one screen and I don't see her.
Yes.
Oh, there she is. Okay, what's your name?
Corey Davis.
Okay, you got her. Okay. All right. What is plaintiff's claim in this case?
With costs, Your Honor, $3,760.03.
All right. Ms. Davis, how are you intending on getting that paid?
I have the December amount, and next week I'll pay the January.
Say that again.
I have the December amount. I have the December, and I'll bring the January next week.
Next week? Okay, so how much do you have now that you can pay?
It says 1730 on this paperwork. But I
Okay,
don't
so you
know
have
if it's
that.
more than that. 1770.
All right. So you can pay about that amount, the 1730, 1770, you can pay that by the 20th, right?
Yes.
And then the balance of this amount, you can get paid by what date?
The end of January.
Okay, so here's what I'm gonna do. I'm going to adjourn your case out to next week, the 23rd, 2026, 2 p.m. That's an in-person hearing. So you'll have to come down to the courthouse. What I would suggest you do is get the 1,700 plus paid into the landlord. Contact the attorney for the landlord and see if you can come to some type of written agreement regarding payment of this, okay?
Okay.
Thank you.
Thank you.
Arbor Woods versus Elijah Ellerson. See them. Elijah Ellerson, no response. You may proceed.
Thank you, Your Honor. There is rent to retain of $1,288.50, costs of $186 for a total due of $1,474.50. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested with the writ issue in 10 days. Arbor Woods versus Destiny Gibson.
Hi, I'm here. Hi, I'm here.
Okay, you got her. All right, what is plaintiff's claim in this case?
Sorry.
We've got Ms. Gibson, Your Honor, at a total with cost of $1,704.
Okay. And Ms. Gibson, how are you gonna get that paid?
I paid it today.
You did?
Yes, I did. While we were on the call, I paid it this morning.
Okay, here's what I'm gonna do then. I'm gonna adjourn it out a week to the 23rd, 2026 at 2 p.m. That's an in-person hearing, but since you got everything paid, you won't need to appear. They'll be issuing a dismissal. You just have to make sure that everything is paid in full. All right?
Yes, sir. Yes, sir.
Okay. All right, thank you. Have a good weekend.
Thank you. Have a good weekend. See you guys later.
Arbor Woods versus Latanya Ingram. Latanya Ingram, no response. You may proceed.
Thank you, Your Honor. There is rent to retain of $1,865.78, costs of $186 for a total due of $2,051.78. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Arbor Woods versus David McLeod. He's here. Yes, I see the name. McLeod. David McLeod. I have him on there, but I don't. You trying to prompt him? Oh, maybe. McLeod. I'll pass the matter and call it back up momentarily. Let's get those that are paying attention. Arbor Woods versus Sharice Roberson.
Thought I saw Roberson, Your Honor. Oh, yep, there she is.
Yep. Ms. Roberson, you'll have to unmute. She's trying. You see the microphone on there? She's on a phone.
David McLeod?
There you go.
Oh,
We
there
have
you
you,
go.
Ms. Roberson.
I'm sorry.
No, it's okay.
Okay.
All right. What is plaintiff's claim in this case?
We're still on the Roberson matter, Your Honor, correct? Even though Mr. McLeod did,
Yeah, we're on the Roberson matter.
okay, the total with cost, Your Honor, $228.98.
$228.98. Ms. Roberson, when are you gonna get that paid?
So, right, that was, for me, I didn't know that, I had a balance from last month. I paid with the cashier's check and I paid this month and I was late. So I paid with the cashier's check. So, Your Honor, I can, have this, amount paid in full by January the 21st, next Wednesday. And I maybe even be able to, take my payment into the office with the cashier's check before that, but if not, I know by the 21st for sure.
All right, Ms. Roberson, here's what I'm gonna do.
Okay.
I'm gonna adjourn this out to the 23rd, 2026 at 2 p.m. That is
Okay.
an in-person hearing, but if you have everything paid, which I think that you will, you don't need to appear.
Okay, thank you so much.
All right, thank you. Have a great weekend.
You too. Thank you so much. Bye-bye.
Bye-bye. Arbor Woods versus Benny Ross. And Jaya Ross.
Here.
Okay. All right, what is the claim in this case?
With cost, Your Honor, $1,514.35.
All right, and how are we gonna get that paid, folks?
I paid that today.
You paid it today?
Yes.
Okay, then what I will do, I'll indicate that in the file. I'll adjourn it out to the 23rd, 2026 at 2 p.m. If everything's paid in full, you don't need to appear down here, and they will dismiss the case, okay?
Okay, you said the 23rd?
Yes.
Is that on Zoom again, or is that?
No,
You said,
that's an in-person hearing, but listen to me. If you paid everything, you don't need to come down to the courthouse.
Okay, okay.
Okay?
Okay, thank you.
Thank you.
Okay.
Arbor Woods versus Karen Sandoval. Sandoval, they are not checked in. You may proceed.
Thank you, Your Honor. There is rent to retain of $91.05, cost of $186 for a total due of $277.05. We'd ask for a default possession only judgment with writ to issue after 10 days, and I suspect in light of the court's policy, there would be no writ without hearing in light of the balance.
That's correct. Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested with a writ to issue in 10 days, no writ without a hearing. Court calls the case of Arbor Woods versus Eric Stewart and Jane Wesley. Mr. Stewart's here. All right. What is the claim in this case?
With costs, Your Honor, it is $1,342.56.
All right.
That's for
Mr.
January,
Stewart?
right?
Yes.
Okay, yes. I plan to pay that by next Wednesday.
The 21st?
Yes, Wednesday, yep.
So you're going to pay the entire balance by that day?
That's the goal, yes.
Okay. So what I'll do is I'll adjourn this out to the 23rd, 2026 at 2 p.m. That's an in-person hearing. But if you have everything paid, I don't need you to come down here.
Okay, I normally do.
The case will likely be dismissed, okay?
Okay. Yes, sir. Thank you.
All right. Thank you, Mr. Stewart.
All right.
Court calls the case of Arbor Woods versus Tarina Taylor.
I'm here.
Oh, there she is. All right. That's Miss Taylor, right?
Yes.
All right. All right. What is plaintiff's claim in this case?
With costs, Your Honor, $4,430.44.
All right. Miss Taylor?
Yes.
How are you going to get that paid?
Well, it got that high because I moved here off of a false eviction. And come to find out I did not have to move. So I had a discussion with the office in written paper saying that they was gonna reimburse me and pay my first 2 months. And they never did, and I'm taking them to court, but I just started a new job, so I was gonna ask if I can have like 30 days.
Well, hold on. So the people that are going to pay the 2 months, that's not Arbor Woods. That's some other landlord.
Yes.
All right. And have you filed an action in court regarding them?
I had brought this up to their attention a couple of days ago when I received the paper. Well, not really a couple of days ago, but when I received the paper, I brought it up to their attention, and they told me I can't talk to nobody, that I have to email them, and I've emailed multiple times, and they have not reached out to me.
Who is that?
Danbury Park Manor.
Danbury Park?
Mm-hmm.
Okay. All right. Okay, you just started working?
Yes, a new job, because my job was far, and then my car ended up messing up, so I had to get my car fixed. I lost that one, so I ended up having to find a new job.
Okay. Do you have anything you can pay over this next week?
I can try.
Okay. All right. You're just not sure?
Not
All
sure.
right. What I will do, ma'am, is I'm going to adjourn this out to the 23rd, next Friday, 2026, 2 p.m. That's an in-person hearing. Have you tried to seek assistance through Hawk or other agencies?
Yeah, I have is it DHS for SER? I haven't got anything back. I've never had to deal with nothing like this. So I really don't know what to do.
All right. Do an SER. You did an SER, correct?
Yes.
Okay, so in your paperwork, there's what's called a rental assistance form. You need to fill that out and get that to the court by next Wednesday.
Okay.
Okay? And making sure to put your tracking number that you have for your SER.
Okay.
Okay, have you called Hawk at all?
No.
All right, let me give you their number.
Okay. 1 second. Where's my school book bag? I do not have a pen. My book bag must be outside. Oh.
Okay, it's a real easy number. It's
Let me go to my sister and see if she can type it down.
okay.
Can you type down this number for me, please?
I'm sorry?
I was talking to my sister to take down a number for me.
Okay, it's 961
961
1999.
1999.
Yes, ma'am.
Okay.
Okay, call them and see if there's anything out there that might assist you in the interim while you're dealing with your prior landlord.
Okay.
Okay? So I'll adjourn it to that date at 2 p.m. That's an in-person hearing, so you'll need to be down here at the courthouse, okay?
Okay.
All right, thank you.
Thank you.
Arbor Woods versus Lisa Thompson. Pardon? Lisa Thompson? Not here. You may proceed.
Your Honor, my client is actually trying to work out a resolution with Ms. Thompson. Can we adjourn this matter to February 6th, assuming the court has a docket on that day?
February, I do, don't I? That's final settlement. I'd have to go to the 13th.
That's just fine, Your Honor. My hope is that it'll be
All right.
resolved and we don't need to appear anyway.
All right, February 13th, 2026 at 12 noon.
Thank you.
Thank you. And Arbor Woods versus, is it Creether Vaughn? Sharitha Vaughn? Vaughn? No response. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,752.72. Costs are $186 for a total due of $1,938.72. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days. Arbor Woods versus Kimberly Waters. Kimberly Waters, not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of $653.78. Costs are $186 for a total due of $839.78. We ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days. Arbor Woods versus Patricia Wellman and Raymond Wellman.
Good morning, Your Honor.
Good morning. All right. What's plaintiff's claim in this case?
With costs, Your Honor, $1,927.15.
All right. And folks, how are you intending on getting that paid?
We have the King County or Washtenaw County veterans that is going to pay it off by next Wednesday.
Okay, so one or both of you's a vet?
My husband's a vet.
Okay, what branch?
Navy.
God bless you. Finally, we have somebody from the Navy. I'm getting all these Army folks, Marine, Air Force, and the Navy folks are far and few between.
Yeah.
All right. So that's going to be paid off next Wednesday, you think?
Try next Wednesday, Tuesday or Wednesday.
All right, fantastic. Here's what I'm going to do. I'm going to adjourn it out to next Friday, the 23rd, 2026 at 2 p.m. Now that's an in-person hearing. All right. But you don't have, if everything's all paid off, you don't have to be here. Just check with your landlord and make sure it all got paid.
Okay.
Tell them if something happens, tell them what happens at 2. You have to be at the doctor.
What'd you say?
Tell them.
I have doctor appointments every day at 2:36 in Royal Oak, so.
Okay, so if they get it all paid, you don't have to be here. You can go to your doctor's appointment, okay?
Okay, very good.
All right. And sir?
Yeah.
I'll just thank you for your service. And what I try to say to all vets, I appreciate what you did and the sacrifices that you made, because of you, I get to do what I get to do. And it doesn't go unnoticed.
Yep, thank you.
Thank you, sir. You guys take care of each other, please.
Okay.
Thank you.
I gotta go pee-pee. You gotta go pee-pee?
Court calls the case of Arbor Woods versus Brandon Wilson. We have that. What's your name?
Brandon Wilson.
Okay. What is plaintiff's claim in this case?
With costs, Your Honor, $3,599.34.
All right. And sir, how are you intending on getting that paid?
I'll be able to pay $1,500 with the next Friday.
By the 23rd?
Yep.
Okay, can you pay that early in the day?
Yes. Yes, I should be able to pay it early in the day that Friday.
All right. So the earlier the better, so that we have a record of it. I'll adjourn this to the 23rd, 2026 at 2 p.m. At 2 p.m. That's an in-person hearing. So either you or Kimberly need to be down here on that date. Okay?
Okay, I got to work that day, so we'll figure it out.
Okay. So get that down here, and you also feel free to contact the plaintiff's attorney's office and see if you can arrange something for the payment of the entire balance at some point, okay?
All right, thank you.
Thank you. And I'll do the recalls here. Arbor Woods versus David Lloyd.
David McLeod?
McLeod?
McLeod.
McLeod,
Yeah.
I'm sorry.
Yeah. Hey, I was
All
here
right.
before, but I couldn't, you couldn't hear me.
Okay. All
Thank you
right,
for
very
taking
good.
the time. Yeah.
Okay, what is plaintiff's claim in this case?
With costs $1,823.72.
All right. Sir, how are you intending on getting that paid?
Well, first of all, I got a lot of money tied up in probate. My son, Aaron, was the attorney for the state. What do you call that? The attorney general, or I don't know. Anyway, he wrote a check from that account and it was closed. So that put me a month behind, and I just found that out. I'm 76 years old. And so that's a month there that he paid, and I don't know if that's illegal to write from a check like that, but maybe he didn't know it. You know, he wrote it and then they grabbed it for probate court. But it's been since September when my brother died, so that's 4 months. They should be coming out of probate anytime. Secondly, I get a check for retirement on the 1st of February for $1,000, and then my Social Security comes another week or so after that. I think it's this second Wednesday of February. So I just need a stopgap in between. And plus I've been scammed. One of my neighbors, in fact, scammed me, you know. That's not good.
So,
I'm selling my
sir,
place. I'm selling my place. I got cash buyers, but I just have to have money to clear this place out before they give me the money. So I got all these things coming in for money, but I'm caught in the middle, especially at my age.
all right. Have you contacted Housing Bureau for Seniors or Hawk?
Contacted what, sir?
Housing Bureau for Seniors?
They speak up for seniors.
Yeah, and they sometimes can help with payment.
Oh, you don't have closed captioning, do you?
We do. What did you need?
Well, I just need to hear what you said, who to contact, because
Okay.
I seem like I went and talked to the office here, and they didn't seem to
No, it's
have
okay.
any patience.
So, I'm Mr. McLeod, and can
Yeah.
we type this into him?
McLeod.
We're gonna type a chat into you. What I'm gonna have you do is contact Hawk. They should be able to help direct you to Housing Bureau for Seniors and the like, okay? Oh, you muted yourself. Mr. McLeod?
Hello?
Hello?
Yeah, can you hear me now? Yeah.
We can hear you. My
Okay.
staff is typing in the number for Hawk into so you should see that come across your screen.
Okay.
Okay, give them a call and they'll be able to at least direct you in a particular direction, maybe to the Housing Bureau for Seniors and the like, okay?
Well, I don't want to lose this place. I can't move. I want
No, we're not looking for you to lose it either, sir, okay? Oh, you muted again.
I will get the number and give them a call.
Okay, I'm going to adjourn this case out to January 23rd, 2026 at 2 p.m. And
Okay.
that's an in-person hearing. So if you can make it, you need to come down to the courthouse, okay?
All right, I'll come down to the courthouse. We'll get this straightened out because I got this all cash flow coming in, but it's not until early February. So maybe there's a
Gotcha.
stopgap. All right, thank you for your time, sir, and have a great weekend, and God bless you.
And Your Honor, before
Thank you.
Mr. McLeod leaves, he said something and I wanted to make sure that he understands requirements under the rules and regulations. I don't know if his buyers will know to do this. I just want to make sure that he follows the parks procedures. Mr. McLeod, if you do end up selling your home to one of the buyers you mentioned, please make sure that if they intend to keep the home on the site, that they get into the management office to apply, get approved before you give them the title.
Oh, yeah, before I give them the...
Yes, sir.
You
Before
still
you
there?
transfer
Yeah.
them the title, just make sure that they've gotten their application in and that they've been approved by management.
Okay. You say you have a phone number for me?
Yes, did you see it?
No, I don't see it.
It's in the chat. You got something to write with, Mr. McLeod?
Yeah, I do. I do.
Okay, it's 734 area code. 961.
Yeah.
1999.
Oh, that's the number you gave before. I've been on here for 2 hours. All right,
Okay.
961-1999. God bless you, sir, and thank you, and have a great weekend.
Thank you, and you also, sir.
And I will stay in touch with the attorney there too, and the office.
Okay.
All right, thank you. Bye-bye.
Thank you. Northville Crossing versus Tony Rogers. Recall. Miss Rogers, there she is.
I'm here.
Okay, what is plaintiff's claim?
With cost, Your Honor, $2,014.
Okay. Miss Rogers, how are you going to get that paid?
I spoke to the office yesterday. I'm going to be dropping off 1,000 in a money order tonight and then the rest next week.
Okay, so you're gonna pay 1,000 today sometime or tonight.
Yes.
And then when are you gonna pay the balance?
I really absolutely, if I could get until not this coming Tuesday, but the following Tuesday, that would be the best. But if I have to beg, borrow, and steal, I can do it by the 23rd if I need to, but I don't get
Okay.
paid again until that following
I got
Tuesday.
you. So here's what I'm gonna do. I'm gonna adjourn it to the 23rd, 2026 at 2 p.m.
Okay.
Okay? What I'm gonna suggest you do in the interim is get the $1,000 in, and
Yes.
then either contact Ms. Dornbush, the plaintiff's attorney, see if you can work out a conditional order of dismissal or the
Okay.
rental office, okay?
All right. Thank you so much.
Thank you. Have a good weekend.
You too.
And then I've got Northfield Crossing versus Ingram versus Kilgore versus Kramer versus Schreiner versus Schultius, I think that is. Arbor Woods versus Bishop versus Courtney Cruz. I think I saw her on there. Arbor Woods versus Shakaya Holmes Howard. Arbor Woods versus Kaba Isa. Arbor Woods versus Patterson, and Arbor Woods versus Tierra Wafer, and Arbor Woods versus Renisha Yarborough. All of those matters are dismissed on plaintiff's motion without prejudice.
Your Honor.
Thank you.
I will see you in 45 minutes.
Yes, ma'am. Syed Hussein versus Obey El Aman. And Yola El Abad.
How are you, sir?
I'm doing well. Are you stationary, sir?
Yes. Just 1 second.
I'm talking to Mr. El Abad. I see
am,
you're
yes.
you are. Okay, fantastic. All right, this is a non-payment of rent case. Mr. Hussein, how much
Yes,
are you claiming is owed?
As of right now, we are at $3,220 with the late fees. And it's been continuous late payments since last April.
Okay, I don't know if I asked that, but okay, so it's 3,220. Mr. El Ahmad, how are you going to get that paid?
Yeah, Your Honor. I'm not sure where the 3,220 is coming from. This case is in regards to December's rent, which was the remaining rent due was the $500 plus the late fees of $380. I paid the $500 last week, and all that remains is the late fees of $380.
How much is the late fee?
It's actually
It's $380.
How much?
$380, sir.
For a late fee?
Yes, that's what I was charged, sir.
A late fee has to be reasonably calculated. It can't just be a penalty, sir. It has to be reasonably calculated to the collection of rent, and I don't think that is.
Right,
And so I
and-
think you may have been overcharging a late fee to these folks.
Actually, I was being generous because it was supposed to be $20 a day for every day he was late.
Okay, well, that's going to be a matter of perspective. Here's what
Right,
I'm going to do. I'm going to adjourn this matter out 1 week. I need you guys here in person.
Okay.
The
rent?
January 23rd, 2026 at 1 p.m. That's an in-person hearing. I want to see, Mr. Alamat, how long have you lived in the place?
I've lived there since mid-December of 2024.
Okay, I want a ledger of each late fee. If it's been this amount, I want a ledger of each late fee that's been paid.
I just had a quick question for you, if you don't mind.
Yes, sir.
So I, as for this case, which was the December rent, I have paid that in full aside from the late fees. So what do I do on my end? Do I pay the $380 or do I just hold still till next Friday?
What I want you to do is hold still till next Friday. Don't pay the $380 right at this point. But even
Yes,
if you
Your
pay
Honor.
the $380, even if you pay the 380, it's gonna go to your January rent, which is currently
Right.
due.
Right, that's due right now, so.
But
it's
I
26.
have a feeling gonna have to do some accounting, because that late fee is,
Right,
that's-
I mean,
that
like
late fee may
before,
be too high.
right.
All
but
right, we'll
before-
see everybody next week.
Okay.
Thank
sounds
you.
good.
Thank you, Your Honor.
Court's in recess.
Late fees. Fuck the late fees. Fuck
the defendant tested positive for alcohol after urine analysis and again denied usage. Mr. Paul, how does your client wish to proceed on the motion to revoke probation at this time?
Judge, we need to have a hearing. I cannot have the hearing today. I've just gotten some new reports that may be contrary to some of these things that's in this motion. So I just got some drug analysis from Kelly Compliance, and some of those are on the same dates as alleged in the motion, Your Honor. So I would like just a short 2-week continuance, continue this to the 30th, so I can put together those documents so I can, so we can have a contested hearing.
All right, defendant denying the allegations of violation. We will set this for contested hearing. Ms. Gillette and Ms. Morgan CSO, does that date of January 30th at 10 o'clock work for the two of you? That is the one you're here on, isn't it, Ms. Morgan? Well?
Yes, Your Honor, I am. And that should work.
Okay, thank you. I was beginning to think my volume wasn't working again.
As
All
long
right.
as we're done by 11, it'll be fine. I have an 11 o'clock with Judge Ricky.
Well, I don't make any guarantees on time, but we can, all right, let's set it for 10 a.m.
All right, sounds good, Judge. Thank you.
You're welcome. Can okay. Missy, will you make that time, that note on the time that we need to keep it moving?
Well, we can just take that up first, Your Honor.
That's what I'm thinking. All right.
Well, great minds think alike.
Okay. All right. And so Ms. Hunt, you're going to be continued on your bond. No alcohol, no illegal drugs. Follow your probation officer's directions completely. Anything else, Ms. Gillette?
No, Your Honor. Thank you.
You're welcome. Then Ms. Hunt is excused.
Thank you, Your
who-
Honor.
You're welcome. Who else do we want to take up at this time, if anyone?
I'm back,
Judge,
Judge, by the way.
May I
Bill.
be excused, Your Honor? It was my only case this morning.
Yes, thank you, Ms. Jones.
See you later.
Have a good one, Jill.
Bye, guys.
Judge, I would like to take up 2 quick continuances, and then I'd like to talk to Mr. Dean.
Okay.
I object to all of that. Yeah, that sounds good.
Especially the speaking to me.
No, Richard, I'm anticipating our discussions every other Friday.
All right, so
If
Missy
people only
needs,
knew.
so if Missy needs to put you in a breakout room,
Well, let's take up these two quick continuances I have, Judge, because I do have some announcements in a couple of cases. And, then Mr. Dean and I can meet.
Okay. Who
That's
do you want
okay
to
with
take
you,
up
Paul.
first?
Let's take up Helper. She's on the screen.
Will be on the record in GW 2025 TR 573, State of Kansas versus Amy Yvonne Coker. Please announce appearances.
State appeared by and through Assistant County Attorney Paul E. Dean.
Richard Paul on behalf of Ms. Coker, who appears by Zoom to separate location of council. Judge, this is a driving while suspended and no proof of liability insurance. I've gotten almost all of the paperwork that shows that she has current insurance now in her license. But there was one document missing that I need to get from Ms. Coker after looking at what she had sent me, so I can give that to Mr. Dean, so we can come to plea negotiations. Judge, if we have time on the January 30th at 11 docket, if we could put it there, that would be great. Since this is my last month, I want to try to take care of as many cases as I can through disposition before then, so I don't leave things hanging.
All right, Missy, January 30th, you have time?
Yeah, that'd be fine.
11, did I hear?
Yeah, 11, please, Your Honor.
Okay. All right, Ms. Coker, I'm ordering that you reappear January 30th at 11 a.m. and be available should Mr. Paul need to talk to you between now and then.
Yes, we will. We'll need to talk.
All right. So Ms. Coker is excused at this time. And
Thank you.
You're welcome. And
Amy, I'll
next,
be in touch next week, okay?
Yes, sir.
all right, Mr. Paul.
Mr. Darlington next, Your Honor. He's on the screen. Matthew, start your audio and video, please.
We are on the record in GW 2025 TR 526, State of Kansas versus Matthew Keith Darlington. Please announce appearances.
State of Kansas appeared by and through Assistant County Attorney Paul E. Dean.
Mr. Darlington appears by Zoom in a separate location than his counsel, Richard Paul.
And how does he wish to proceed today at this status conference?
Your Honor, this is our first time up. After speaking with Mr. Darlington, he has applied for a restricted license. He's in that process through the state. He has asked me to ask for 1 month so he can get that accomplished. So then hopefully he can, Mr. Dean and his attorney can enter into plea negotiations.
Can we do this, Missy, February 13th at 10 or 11?
How about the 27th?
27th works for me if that works for everyone
At
else.
10.
2/27 at 10.
Thanks.
All right, thank you.
All right, now, if you wouldn't mind putting Mr. Dean and I in a breakout room, Your Honor.
Very well. Missy, if you would, please. And Mr. Darlington, you're excused.
Mr. Darlington, you're free to go.
But you must be back here 10 a.m. the
Thank you.
27th. You're
All right.
welcome. Okay, you may go. Before I put you all in a breakout room, oh, he already left, didn't he? Okay, I was going to take up Kimberly Adams, but she's not Mr. Paws. I don't think she is. We'll take a recess again.